Hear, all persons having business with the appellate may draw near, give your attendance, and you shall be heard. Will you please read it? So, good morning, everyone. Welcome to the Appellate Division First Department. We have oral arguments for today, November 26th. So please ask for the time that you actually need in order to get out the salient points of your arguments. Please keep in mind that we have read your arguments. We are fully familiar with your briefs. We have about 8 hours of argument time requested, which obviously is not going to happen. Also, before we get started, I want to wish everybody a happy Thanksgiving. People v. Miguel Aguera. 4-1 and 4. Telus Ford v. Port Authority of New York, New Jersey. 4-1 and 4. Matter of Corey. That matter is submitted. Anthony Partners v. MICI. 5-1 and 4. Scottsdale Insurance v. the City of New York. 4-2 and 4. People v. Isaac Isera. That matter is submitted. People v. Aaron Young. 5-2-5. 217 versus VIR Construction. 5-2 and 5. By the way, People v. Aaron Young, that case is going to be called first. Buckley v. Hearst Corporation. 5-2-5. Aurora Corporation v. Cookman Best Insurance. Is there an appellant? Okay, so 3 minutes then. Valley National Bank v. Community Protestant Church. 5-2-5. People v. Lassiter. That matter is submitted. Altamirano v. Frick Collection. 3-2 and 4. Board of Managers v. 1055 Madison Avenue. 5-2-5. People v. Johnson. That matter is submitted. Schuler v. Kushner. She's behind you. Go ahead. Yes. How much time are you requesting? I'm sorry? Certainly. 4-1 and 4. Fuentes v. Parkchester South Condominium. 4-1-4. People v. Peterkin. Matter is submitted. People v. Tion Seymour. That matter is submitted. 885-887 Caldwell versus 885C Realty.
Yes, Your Honor. Good morning. Raphael Cantillo for the comment.
You're appearing pro se?
Yes.
Um,
Your Honor, Howard Leftwich would have responded 5 minutes, but Your Honor, pro se litigant has not requested this, that he has an attorney.
I'm sorry?
Pro se litigant has an attorney.
Well,
He's not pro se.
Well, we're going to get to that during the arguments, but thank you. 4-1 and 4. Justice Mendez is recused on that matter. Also, we have interns here from St. John's. You guys from St. John's? Hello. They're also from the Franklin H. Williams Commission, and so we want to welcome them here. And so some of them do, in fact, wish to become attorneys, so please do not dissuade them or do anything which would dissuade them from that career path. As I stated, first case for argument, People v. Aaron Young.
Good morning, Your Honors. May it please the Court. Cara Lubini, Center for Appellate Litigation for Mr. Aaron Young. The lower court was wrong in finding that the CPL allowed a jury trial on tolling. It presented Mr. Young with a false set of
You
choices.
preserve the Erlinger issue in this case because the court says, Mr. Young, are you waiving your constitutional claim that because of the tolling involved in your predicate felony statement, you're entitled to a jury trial on the question of whether the 10-year period set forth in the statute has been told pursuant to Erlinger versus United States? And the defendant says, yes, sir. So the issue is squarely presented to the defendant, and he says he's waiving it.
The waiver was after any litigation on Erlinger. So the defendant argued that Erlinger applied. He won that argument. The lower court found in his favor. And the court found after that that if he wanted to go to trial, if he wanted to litigate tolling, he would have to go to trial first. So any waiver or admission of tolling, which there was also none, was coerced by this false set of choices that the lower court presented Mr. Young with.
Did you argue in your papers that there was some type of coercion on the part of the court?
I don't know that I used the word coerced.
You
Your
just
Honor.
did. I'm just saying, you just used the word coercion. That's why I asked you.
I'm not sure if in the papers I did, but it was certainly induced by this.
Well,
false
I
set
don't
of
know that
choices.
one. I know that it was induced. I do know we do have other cases where there is a situation where there may be an adverse or negative ruling towards a defendant, or what a defendant may view as an adverse ruling, and then the defendant does in fact plead guilty, and we have not found that to be coercion. And I'm thinking in the context of Molyneux. But as to my colleague's question, now I recognize that there was an email or excuse me, a letter sent to the court saying, by the way, court, I just want to make you aware of Erlinger. But at the time of the arraignment on the predicate felony statement, also at the time of the arraignment on the predicate felony statement, the defendant says absolutely nothing. He does not contest the constitutionality of it. He doesn't say that wasn't him in the predicate felony statement in terms of the offenses. He doesn't say, oh, wait a minute, remember I said that, that Erlinger applies? He says nothing.
Right, because the court presented him with this false set of choices. The court said, if you want to plead guilty.
Why would that preclude him from again stating and for preserving for the record his objection?
So first, for preservation purposes, People v. Finch says that he does not have to re-raise any argument that he had previously lost. To do so would have been futile. Second, the court said that if he wanted to litigate tolling, he had to do so before a jury after he went to trial, where he would have been risking almost double the sentence that the prosecution offered. So if he wanted to plead guilty, he had to accept the prosecution's predicate offer of 2 to 4. And if he wanted to litigate tolling, the law of the case constrained him to do so before a jury after a jury found him
I hear your
guilty.
point about that, but does Erlinger, after all, apply to this? Because Erlinger involved adjudication of what the defendant did, whether the defendant committed those crimes in a certain period of time. Here what we're concerned about is whether the states, we're adjudicating the states' records as to when the defendant was incarcerated, whether he was convicted. Why does that fall under Erlinger?
So first of all, that's not part of this case because the lower court found in the defendant's favor that Erlinger did apply. So under LaFontaine.
Are we bound by that finding?
I'm sorry?
Is the appellate division bound by that
Yes,
finding?
it makes that issue unreviewable. Furthermore, it's
Why?
unpreserved.
Under what case?
Under LaFontaine.
I'm sorry?
Under LaFontaine. It's also unpreserved and it was waived. The prosecutor essentially joined issue with the court in how it laid out his choices for Mr. Young.
I'm not sure. I'll accept what you're stating, but I'm not sure that that is correct. That we will be, if in fact there's a misstatement on the part of the court, I don't know, or a misapprehension as to exactly what the law is, or we disagree. I don't know that we are bound by that. But please continue.
If the court disagrees with the lower court's finding, this case is not a good case to resolve that question because there was no litigation on the part of the prosecution on that issue. But second, as to the merits point, tolling is a fact
Can I
that is-
interrupt for a second? I read People versus Lopez that you primarily rely upon. There was others as well. They talk about the double bind. But isn't
we
it
talk about, I'm sorry, Your Honor?
double bind? That
Double bind?
meaning that you can't have a judge because the state law says a judge and Erlinger says a jury. So they call that a double bind.
Sure.
So it's incompatible.
Yes.
So why is it incompatible In our case, whether a judge under New York state law presides or a jury pursuant to Erlanger, you waive both. So on our situation, it doesn't really much matter. You waive your rights with respect to the tolling, whether it's a judge or whether it's a jury.
But the waiver was on the basis of a faulty legal ruling and a faulty sentencing range. There's no case in the state of New York that has found that if a defendant pleads guilty to an illegal sentencing range, a waiver can somehow insulate his sentence.
So your argument is that the whole rubric, the statute, in terms of a second felony offender, is unconstitutional.
In this case, because Mr.
Why
Young-
only in this case? I
Well,
mean, to
because
follow
Mr.
that
Young's-
through, it would have to be in every case, because if you agree that Erlanger applies, then that means that our whole statutory framework is unconstitutional.
Where a predicate sentence relies on tolling, yes, absolutely.
Okay, so then how do we make that determination? Isn't that something for the legislature to figure out?
That's exactly the case, because lower courts cannot fashion new jury procedures out of whole
So
cloth.
all the Supreme Court can do and all we can do is follow the laws that are currently on the books.
Where the statute expressly forbids a jury trial on tolling, lower courts cannot create those procedures out of whole cloth. They'd be faced with an unending number of questions.
And this is
about
all
how-
based upon your argument that Erlanger applies.
Yes, and the judge agreed that it did apply, and
Okay, so we're going to take that out of the equation in terms of what the judge agreed or did not agree to, right? How do you then square Hernandez?
Hernandez, there was no litigation at all about Erlanger. That's just not on point, Your Honor. Here, the defense argued
Well,
that
Hernandez
Erlanger-
dealt with preservation, right?
but there was no litigation at all. In fact, the lower court proceedings preceded Erlanger, and that's why there was no litigation on that.
And
But
when
here,
you say litigation, what are you referring to? Just
the defense
argument?
at the trial court raising that Erlanger applied.
And
That
that
just didn't happen.
constitutes litigation?
Well, there was no objection, there was no argument on the part of the defense to say that Erlanger applied. So here, Mr. Young raised the very argument that Mr. Hernandez did not.
Thank you. You have time on rebuttal.
Thank you, Your Honors.
Good morning, Your Honors. May it please the Court, Addison Esley for the people.
So your colleague claims that under LaFontaine, the appellate division could not disagree with Supreme Court as to the applicability of Erlanger. Do you have anything to say about that?
Could you say the last part of that again? I'm sorry.
What do you have to say about that? Your defense counsel says we're bound by the trial court's decision that Erlanger applies. And my question is the appellate division free to come to the conclusion that Erlanger doesn't apply to this situation?
Yes, of course, Your Honor, because as Your Honor pointed
This
out,
isn't a
defendant
this
explicitly
doesn't
waived.
fall within LaFontaine.
This does not fall within LaFontaine, Your Honor. Defendant explicitly waived this argument, as you pointed out. And as Your Honor pointed out, he never challenged the underlying facts of the predicate felon statement.
See, this is the question I was going to raise with your friend, but I'll raise it with you. Erlanger does allow the judge to determine the facts of a conviction, correct?
The facts of a prior conviction,
Of a
yes.
prior conviction.
Yeah.
So if the prosecutor presents certified copies of convictions and the court takes judicial notice of those certified copies of the facts of those convictions and just does the ministerial act of math,
Yeah, that's enough, Your Honor.
that should work here without violating Erlanger,
Yeah,
correct?
and we don't even need that here, Your Honor, because defendant himself admitted to all of this.
Right.
It wasn't just the defendant or the judge going through certified records. Defendant himself went through a step-by-step process during the plea colloquy in which he admitted to
Specifically agreed to that predicate felony
Yes.
statement.
He did
Absolutely.
not challenge it. Well,
Did not challenge
that's the question. Erlanger states that facts have to be resolved by the jury.
or freely admitted by the defendant during a guilty plea, Your Honor, which is exactly what defendant did here.
Those are facts of the defendant's conduct. That if there's an adjudication of what the defendant did, then it has to be done by a jury.
That's right, Your Honor. And here, we're determining what the government did here in that when the government was holding defendant in custody. So it's also just a completely separate kind of fact-finding, as the people pointed out in our briefs.
Did the defendant have to, at the time that he was being arraigned on the predicate felony statement, did he at that point in time have to again raise a challenge and state that that under Erlinger this should not be occurring, that a jury should be making this determination?
Regarding the precise moment in which defendant needed to raise this issue, he just needed at some point in these proceedings to challenge these underlying facts from the predicate
Did he
felony
have
statement.
to raise it again? I mean, the court had made it, a letter was sent to the court drawing the court's attention to Erlinger. There was a conversation between the court and the defendant, defense attorney, prosecutor, as to the applicability of Erlinger. And then the court made its determination, and then the defendant entered the plea. At that time, was it incumbent upon him to re-raise this issue?
If he wanted to stand by that prior ruling, Your Honor, yeah, but defendant then turned and waived the entire issue whole cloth and then admitted to all the facts during his guilty plea. So if he wanted to stick by that ruling that the lower court made, that Erlinger applied and the lower court was willing to call an Erlinger jury or have a jury at some point prove those facts, defendant shouldn't have affirmatively waived that issue after the fact then and pled guilty and accepted the people's offer.
And if your friend states that Hernandez does not apply in this case?
Hernandez applies fully, Your Honor, because in Hernandez, like here, the defendant never challenged the predicate felon statement below, and so as an initial matter, there was just no issue for that court to reach with respect to Erlinger, because by admitting those facts, defendant has just taken the Erlinger question off the table like he's done here.
Well, she's arguing that it is distinguishable because here there was some conversation, and also there was no need for further argument by defense because the court stated Erlinger applies.
And then defendant waived it, which is why there was no further argument on it. Defendant got this ruling in his favor, could have taken the case to trial, could have, if he had been found guilty at trial by a jury, then had a jury determine these facts if the lower court had determined such, that he was entitled to such right. But defendant then turned around, pled guilty, waived the entire thing. And so, Your Honor, simply here, just the defendant explicitly, as Your Honor quoted, waived any issue he had pursuant, or any claim he had pursuant to Erlinger versus United States, and he affirmatively did that. And if there are no further questions, Your Honors, we ask that you affirm.
Thank you.
Your Honors, any waiver has to be knowing and intelligent. Here it was not. The law of the case said that, yes, if Mr. Young
Why would
wanted
it
to
not be
litigate...
knowing and intelligent?
Because the lower court ruled that Mr. Young, to litigate tolling, had to do so before a jury. To get to that jury, he would have to first go to trial, risking a sentence almost double the prosecution's offer. So if he wanted to plead guilty, there was no way to litigate tolling. That was the law of the case, and it constrained...
So why then would his actions not be knowing? He was fully aware of what the ramifications were. He knew that either he had to challenge tolling and have it go before a jury, or not challenge tolling and plead guilty.
And accept a predicate offer that relied on tolling, which is illegal. So that was a misstatement on the part of the court, which Mr. Young relied on, as he's entitled to do, and which doesn't require him to re-raise the argument at the predicate arraignment.
But again, you're characterizing it as illegal because you're stating that under Erlinger, it could not go forward, as opposed to under our statute and under our laws.
The statute, the CPL, says that tolling has to be found without a jury. So the lower court said, no, you can get a jury. You just have to go to trial first, and then we'll have an Erlinger jury discuss to litigate tolling. That's wrong. That's illegal.
See, again, that takes us to my colleague's statement in terms of a bind. What then is the Supreme Court to do?
This, just like in Lopez, just like in Banks, the Supreme Court is constrained by the CPL, cannot act as a legislator to determine how many peremptory strikes each side get, how many alternates there are. Not act as a legislator. I'm sorry.
What is left if there's an admission of the predicate statement? What is left to do?
But the admission was after the advice that the court gave him, which was wrong as to Erlinger's applicability. The court said, yes, Erlanger applies. If you want to plead guilty, you have to accept the predicate offer that relied on tolling that the prosecution is
No,
offering
there
you.
was no contingency that you had to agree to the predicate statement.
Yes, absolutely, because the court said, I'm not offering you a first felony offender
You're
offer. The
conflating two
offer-
issues. You're conflating you're conflating that the court determined that the tolling issue under Ellinger, and I understand that. But then your client went ahead and waived and admitted the terms of the predicate statement. So there's no need for a jury or a
That was
a
weeks
judge.
later. So the court said,
Correct,
these are your
correct.
choices. The court said very succinctly, these are your choices, Mr. Young. To plead guilty, you must accept the predicate offer of 2 to 4, which is the minimum as a second. Forced felony offender is not on the table. If you want to litigate
Well,
tolling,
that's interesting. You must accept the predicate offer. Does that translate to you must admit that you're a predicate?
yes, absolutely.
Why? I don't
Because in order to litigate tolling, you have to do
No,
so
but
before a
counsel,
jury.
you're not understanding. So when an offer is made to a defendant, the offer is you're going to plead guilty as a second predicate felon offender, right? At that point in time, okay, the defendant is still arraigned on the predicate felony statement. There is nothing that precludes that defendant from challenging the underlying predicate.
Under normal circumstances,
But
pre-Erlanger,
it's-
that's
I don't
absolutely
understand
right.
why it's any
That's
different.
absolutely right, because the court said the proper party to litigate tolling to is a jury. You can't argue it to a court.
But the court never stated, the court stated the offer is to plead guilty as a second felony offender, right?
Yes.
That's the offer. That goes on every day. Well, not every day, but it goes
that's-
on,
but
in,
that's-
excuse me,
sorry.
that goes on when a offer is made to a defendant. That does not presuppose the fact that the underlying charges or the underlying predicate can be borne out.
But the court said that in order to access that plea offer,
In order to get to 2 to 4, he has to agree to the.
he
that
has
is a
to agree,
predicate
because
felony.
under Erlanger, a jury must determine tolling.
But
The only way to convene a jury is
I
if you go to
understand.
trial.
We're only speaking as to the predicate, the offer as the offer made to the defendant. 2 to 4 as a second felony offender.
Right.
That does not translate to, I don't see how that translate to, but that's assuming you're a predicate. We're assuming you're a predicate. If you are not a predicate, then that's not going to, then
Then
that's
you
not
have
the
to,
offer.
then you have to say so before
No,
a jury and argue
no,
it.
no.
Yes, because if the defendant at the predicate arraignment said challenge tolling, the plea would have been off, and he would have had to litigate tolling after a jury trial on his guilt, and then before a jury,
don't-
because that's
I
what the
don't-
court explained on the record. It's the transcript. The court said your choice is simple. You can accept the predicate offer or go to trial, and then after trial, you can talk to a jury, litigate in front of a jury about how you're not a predicate. That is what the court said.
Okay, thank you.
Thank you, Your Honors.
Thank you both. People v. Miguel Guerra. Yes, you may proceed.
Good morning, Your Honors, and may it please the Court. Marielle Stein of the Legal Aid Society on behalf of Miguel Aguirre, who is present in court today. The prosecution claims this case is moot because Condition 28 and additional Condition 7 are the same. They are
28 or,
wrong.
oh yes, 28, sorry, yes.
Condition
So the
28,
defendant pled guilty to the sexual abuse in the first degree, received 10 years probation. One of the conditions of probation was that he not engage in, what is this,
this is the search condition.
the search condition. So the search condition, this particular search condition was as to what?
So the issue we're raising is about Condition 28 specifically, which authorizes probation officers or police to search his home for drugs, weapons, contraband, things of that nature.
And then Condition 7 talks about containers that may be searched for purposes of computer and computer files for sexually explicit materials, right?
That's exactly right, Your Honor. So there is a,
So you believe that condition 7, by adding the two terms computers and data-related type material, that's somehow the limitation that you could live with because you didn't challenge 7, correct?
yes, 7
And
is,
whereas condition 28 is overly broad, it's like a full-blown search of anything and everything,
that's
correct?
exactly right.
And also has nothing to do with the stated purposes of probation in terms of rehabilitation, because there's no allegation that the defendant ever used illegal substances or was in possession of illegal substances or of any other type of weapons.
Exactly right, Your Honor. As this court knows and has said many times, these conditions have to be reasonably related to the defendant's rehabilitation. We don't contest that additional condition 7 is tailored, it is related, but condition 28 is not. And it just does not need to be. It wasn't discussed at the plea or sentence proceedings. Probation didn't request it when they did the probation interview. This court can strike it, and we think that is a just result.
Thank you.
Thank you, Judge.
Good afternoon. May it please the court. Margaret Crookston for the people. Morning, rather.
Morning.
Your Honors. Just to clarify, the condition allows probation within the scope of their duties to search defendant. It does not allow the police to do so. Just to clarify.
I'm sorry if I said law enforcement, I apologize. It's probation, yes.
Your Honors.
What does condition 28 have to do with the rehabilitation of the defendant based upon the charge, based upon the crime that he pled guilty to?
Your Honor, so in Andrus, this court noted that this is a fact-specific determination, and we think here there are some distinguishable facts, wherein Andrus, they did compare to People versus Velardo, where they said, in Andrus, it wasn't necessary, and they pointed out that probation had not recommended that defendant go through substance abuse training. Here, defendant specifically blamed his alcohol consumption on why he committed the crime. So we had a defendant who's saying, I committed this crime because I was blackout drunk. And so we think that here, where this substance abuse programming is not just part of his probation conditions, it's part of
So
his
probation can go in and search his apartment to see whether or not there are any bottles of alcohol?
Well, Your Honor, he is required, as part of his sentence, as part of the conditions of probation, to undergo substance abuse training to address his admitted issues.
But there was never any issue of drug abuse, and if you read condition 28, it focuses on drug use, drug or weapon use in that kind of context. And that's not here, and we recently ruled that in a case, People v. Carrasquillo, you know, if there's no real, as pointed out, a real relationship between that condition and the person's crime, there's no, it's overly broad. It's not necessary.
Yes, Your Honor, we do understand the way the court has been trending on this condition and finding that there's usually, you know, drugs or weapons are the main portion of that. But here, where probation is the one that is in charge of monitoring his compliance with substance abuse programming to ensure that he doesn't engage in substance abuse, when he specifically said, it was because of my substance abuse issues that I went on to commit this very serious crime where he
The
victimized
Department of
very
Probation
vulnerable.
didn't recommend substance abuse treatment.
Yes, they did, Your Honor.
I thought it stated only that the defendant might benefit from further assessment and evaluation.
I do believe it was noted that he would, I think maybe the phrase was would benefit, but
Right, but, well, it's a little different. They did not recommend that the defendant take part in a substance abuse program. They said it would be beneficial, but they did not recommend that he take part.
Your Honor, I think with this, where we have the record specifically because we have the benefit of the SORA hearing that happened during the sentencing, we can see that the court was very cognizant of the conditions and the level of supervision that defendant would require within.
To be clear, he had no history of any crimes related to substance abuse or possession of a weapon or anything of that nature.
Not, he did have an out-of-state DUI charge, but nothing regarding drugs specifically. Your Honor.
Thank you.
Thank you very much. We ask that you affirm.
Yes, anything on rebuttal?
Just briefly, I don't have much to add. I would just note that Carrasquillo and Velardo are distinguishable in a key respect, which is both of those are weapons conditions, which I believe this court is well aware of. I'd also note that we don't know exactly what the treatment program requires. There's no probation condition preventing him from owning or using alcohol. No history of drugs, no history of weapon use, no history of violence. We believe this condition is inappropriate and should be struck. And with that, I will yield the rest of my time. Thank you, Your Honors, and happy holidays.
Thank you. Telesford versus Port Authority. Yes.
May it please the court, Brendan Fitzpatrick, counsel for the Appellate Port Authority. Your Honors, this court and the Court of Appeals have addressed the issue of Labor Law Section 240 on countless occasions. Here we're talking about a 7-inch differential when the facts
Well,
are.
you know, we recently ruled in Palumbo that
Yes.
there's really no bright line.
I understand.
Let me just finish the thought, sir.
I'm sorry.
There's no bright line height differential. And arguably, whether he was on the lower step, on the higher step, where he could have fallen and God forbid, broken his neck, we've held that that kind of situation is covered by 240.
Yes, Palumbo, this court said its rulings with respect to 240 and heights are evolving. But in that case,
It's
we
not
also,
the rule in the second department, right?
pardon, Your Honor?
The second department view of this is different, right?
Consistently different. I think there are many cases from this department that also hold that a situation such as this would not be covered. We're just simply asking for it to be a question of fact for a jury. This court's decision in Romero, where a plaintiff is walking on basically a raised computer flooring, and one of the tiles breaks and plaintiff's foot drops through a 2 foot by 2 foot opening, 18 inches. This court found that that's not a 240 case. Again, I understand, Your Honor, that Palumbo said this case is it's evolving, but no court in the entire state has ever held that a 7-inch differential, where there was no question.
I thought it was 8 to 12.
Your Honor, I think Mr. Tomechko and the photographs, I believe that at page 409, Mr. Tomechko, when he was looking at it, said from the riser to the depth of the riser to where the step was, where the Corex was, that's 7 inches. That's the depth that.
What is it that he fell into?
Basically, when you have permanent stairs, which is what this was, it's like they call it a pan, which is what the bottom of the riser is. So that's really where it just fell to the.
I thought
bottom of
that
the
was the
pan.
whole point, was that it wasn't permanent because of the cortex, that the cortex was covering
the
it.
stair, the structure of the stairs was
okay.
permanent. This was a permanent marble stair.
But the
At
step
the
that he
top,
actually, the last step or whatever, the step that he actually, his foot went through,
it was the Corex.
it was the cortex.
Yes. So
And was it your witness who stated that there should not have been cortex? If there was cortex, there should have been some support?
yes, Mr. Tomechko said that there should have been a piece of plywood underneath.
Right, something was missing?
Yes.
And an unprotected hole should have been secured?
Yes. But again, Your Honor, I think even if the evolving case law from this department, you still have to go back to some foundational principles, which is from the Court of Appeals as well as this court. And in Quentis against Sephora, this court ruled not so long ago that when you're considering 240, the single decisive question is whether a plaintiff's incident was the direct consequence of a failure to provide an adequate protection against the risk arising from, and this is this court's ruling, physically significant elevation differential.
So,
We do
so
not
my
have that, Your Honor. We do
fair
not.
point. But if that stepper on the top and he went all the way down, would you have the same argument? Oh, it was only 7 inches even though he broke his neck?
Well, again, Your Honor, my issue would be a lot tougher. But I don't believe that when you're talking about, again, you're talking about a permanent structure as opposed where there was other, that's different. I think that's a different situation, Your Honor. You're not talking about in Palumbo where the plaintiff stacked pallets on top of each other as a work surface. You're talking about a permanent structure, so it takes it away from that.
This is the bottom step into a hole below it, and that's the 8 to 12 inches.
This is 7 inches, I think it's 7 inches.
Whatever.
Yes, it's the bottom step or landing.
And if it was the step above it, that was covered by Corex instead of a permanent, it would be like 12 to 13, 12 to 15 inches, is that it?
No, Your Honor, because at the bottom of the pan for each step, it's just a 7-inch drop. That's it. It's 7 inches from the step. That's how steps work. It's not
Thank you.
completely
That's all
falling
on
through
the
the
bottom.
bottom. Thank you, Your Honor.
Good morning, Your Honors. May it please the court, Kenneth Gorman for the plaintiff respondent.
So, counsel, how did we get 8 to 12 when your friend states it's only 7?
The photo at page 409 of the record explains everything. It shows exactly how deep the hole was.
I have the photos. You can go ahead.
Okay, so when Mr. Tomachenko was showing the photo at page 297 of the record, he identified the 7-inch drop from the step below, where plaintiff's foot intended to land. Since the plaintiff's foot dropped from the top of the step, which measured 12 inches to the bottom where his foot landed, this was a 12-inch drop. In Jones versus 4114,
This is the bottom step, right?
excuse me?
This is the bottom step,
I believe
right?
so, right. And his foot was on the second to bottom step, 13.
Oh, I can't see what you're
I'm
pointing
sorry.
to.
His foot was on the second to bottom step, right over here, which was 12 inches from where his foot landed. We're really splitting hairs when we talk about 7 inches because this is the bottom step, but the plaintiff's foot was on the step above that right before the accident.
Then he
happened.
steps onto what should have been the bottom step,
That's exactly right.
and instead he ends up in this hole that's below the staircase, which doesn't really have much depth to it.
It doesn't, but Mr. Tomachenko states at 224 to 225 of the record that the stairs posed a danger to workers using them, and that Corex should not have been used.
Well, the cortex should have been, it shouldn't have been used, and there should have been something under it.
He states plywood over dense styrofoam was the proper securing device that should have been used to cover the hole, and the defendant's failure to use that device establishes foreseeability and their liability as a matter of law.
So really what the case is whether a missing bottom stair of a fixed staircase implicates 241.
If there was a safety device that could have avoided the accident, absolutely.
Well, if the step that was supposed to be there had been there, there would be no problem.
Correct, but the plywood over dense styrofoam that Mr. Tomachenko identified, that should have been used, that was the safety device that should have been used, and it was the defendant's failure to use it, which resulted in their absolute
And
liability.
there's no real dispute that they were on either actual or constructive notice of this.
Absolutely, that's correct. If there's nothing further, I ask the court to affirm.
you.
Thank you.
Your Honor, when the issue really isn't liability, it's liability under 240. And what the Court of Appeals has specifically said, these are, it applies to a narrow class of significant.
Counsel,
Yes.
I thought we're now in the regime of Runner, and Runner changed things that we're talking about gravity related. Certainly by going down the steps, that gravity caused the accident. We're not talking about the amount of inches, whether it's 7 or 12, it doesn't really much matter. There's no de minimis rule. If the force of gravity caused the accident, then 240 subsection 1 is implicated.
Then that would run against every single decision from the Court of Appeals where they have specifically said.
I thought Runner
simply
said the
because-
opposite.
Simply because gravity is involved in an incident, that doesn't mean 240 applies.
Palumbo says the opposite.
Palumbo, again, you're talking about a work surface that was created and plaintiff fell through it. This court has never ruled something similar to this, a de minimis distance. Again, Justice Weber, Justice Friedman, you were on the Fisher case not so long ago where there was a 1.5 to 2 foot or 10 foot or 10-inch drop. And this court ruled that that wasn't covered by 240. We're simply asking for this court to rule that the issue of whether 240 liability should go to a jury. It may be, we may be found liable under another provision of the labor law, but not under 240. The Court of Appeals has never considered such a de minimis distance to be an extraordinary elevation-related risk that 240 should apply to.
Thank you.
Thank you.
both. Anthony Partners v. MICI.
Good morning, Your Honors. May it please the court. My name is Rocco Boza. I represent the appellant.
Counsel, if you could just speak up a little bit, please.
A little louder, Judge?
Yes, thank you.
Okay. Judge, this is a case by justice, what can best be described as justice by an emoji, which resulted in the conviction of Mr. Michi for not only civil contempt, but also
So, counsel, isn't it true that there was an affidavit of service and an email which sent the order to show cause with the TRO? It's not only the emoji. There's much, much more evidence that the trial court below relied upon.
Well, Your Honor, with respect, I don't believe there is much more evidence. There was
Let's
an
do
email.
one at a time. How about the email?
There was an email that was sent. My client did not receive that email. Also,
And how about the affidavit of service?
the affidavit of service indicates cause to be served by, which is pursuant to McDonald versus Ames. That language is not sufficient to establish a proper affidavit of service and establish due process. In this particular case,
I think you read the affidavit of service wrong. I think it says that it was mailed.
it was mailed overnight. That's correct.
So what's wrong with that
But
service?
it was what the affidavit of service was from the attorney who basically said they gave it to Federal Express. There is nothing from Federal Express indicating that it was delivered.
What case or what law requires that you have to get a backup from the UPS or U.S. Postal Service, or here it was done through FedEx?
Yes.
What requirement is that you have to go back and get a certificate or get some acknowledgement?
Okay, so there is no required that you need a certificate. However, the McDonald versus Ames indicates that the method that was used was basically, it's not from a person with knowledge that is preparing that affidavit. It indicates how the papers were served or deemed to be served. But Your Honor, also there is actual knowledge that is required here, and that burden of proof is upon the plaintiff to establish that the defendant did receive actual knowledge. In this case, in order to hold the defendant guilty of both either criminal or civil contempt. So, Your Honor, with respect to what you were alleging, perhaps there was no certificate indicating that there was actually receipt.
Judge Counsel, I just want to be clear, procedurally, you do concede that you're not challenging the affidavit of service as to the preliminary injunction. Is that correct?
Judge, I am challenging the fact that there was no actual knowledge. The affidavit of service, while it purports to be an
Well,
affidavit.
you're not arguing that they were not entitled to the preliminary injunction, right, based upon the lack of service. So that portion of your appeal is abandoned, right?
Well, Judge, no, I don't feel that it's abandoned. We've properly raised the issue, and
You argued that plaintiff wasn't entitled to the preliminary injunction, which the court granted?
no, the court did not grant that, but we certainly preserved that.
Counsel, there was a preliminary injunction that was granted without opposition.
Right.
Well, Judge, with respect, it was not granted without opposition. In fact, there was opposition which was submitted for both applications, while the judge in the decision indicated that it was without opposition. The one opposition, because the two cases were consolidated for the same day.
Counsel, what was your argument in opposition to preliminary injunction? I didn't see anything in this appeal that addressed the preliminary injunction argument. I didn't see anything.
So, Judge, the main focus of our appeal is, in fact, with the actual knowledge of the.
Isn't it true that there's nothing in the face of this record that would constitute any opposition to the preliminary injunction?
Judge, there is our opposition that we submitted with respect to both of these motions.
I'm talking about in the record here, let's say in your brief, do you raise any issue with respect to the preliminary injunction?
Judge, the only thing that I can say is
The
that we.
answer is no. Thank you, counsel.
Thank you, Judge.
Thank you.
Good morning. May it please the court, my name is Rachel Rosenberg, and I'm counsel for plaintiff respondent. There was no opposition to the preliminary injunction, and in fact, there was no raising of the fact that defendant Mr. Michi did not have knowledge of the TRO. Counsel for appellant just stood here and said that the civil contempt should not have been granted because Mr. Michi did not have knowledge. Mr. Michi never said that below. That is outside of the
Is there a
record.
question whether that was actually emailed to him, that the August 21st order was emailed to him?
It was, in fact, emailed, and in the record, we have the email to
Plaintiff's
Mr.
counsel emailed it to him.
I, in fact, as counsel for plaintiff, emailed it to Mr. Michi. I also emailed Mr. Michi at the same email address, notice that we would be presenting the TRO.
So
So,
was there a response to your email?
yes,
That's the emoji, right?
that's the response.
That's what I thought. I thought that was the whole point when your friends talked about this is the emoji case or something of that nature. I thought that was the response to your email was the emoji.
Correct. The emoji is not necessary to find knowledge. Under the Court of Appeals, McCormick, knowledge can be even imputed if, in McCormick, the defendants were found.
Well, I mean, the emoji indicates receipt of the email.
The emoji
And
is-
therefore, some type of perhaps reading of the contents of the email, which, talked about the injunction. So I'm not understanding that argument.
The emoji certainly doesn't hurt you.
The emoji was, as Justice Gray said, the proverbial finger.
Right, that's basically what it was. It wasn't a happy face.
Was happy.
It wasn't a LOL, right?
Your Honors, if there are no further questions, we ask that the orders be affirmed.
Thank you.
Thank you.
Judge, actually, it was a happy face, but it shouldn't really matter what it was, a happy face or a sad face.
But it was an acknowledgement, whatever face it was.
No,
it
Your
was
Honor.
an acknowledgement of the email
No,
and
Your-
therefore knowledge.
Not correct.
No.
No, Your Honor, because there was a string of emails which was going back and forth, such as a time to meet. The emoji was sent after the emails from counsel basically said, hey, can we meet sometime to talk? And at what number can we call you? Emoji. That's when the emoji
Counsel,
came in.
but at the end of the day, your client submitted an affirmation or affidavit, and he never denied not being served with a copy of the court's order saying, leave everything alone.
Absolutely, he denies it, and he denies it today. He denied it at the
He can
hearing.
deny it all he wants now, but back in the court below, he didn't, in his affirmation, he didn't deny it.
Judge, that wasn't my affirmation. The judge.
That was his.
In my affirmation, there was clearly indication that he never received.
Who received it? I mean, you're affirming or stating that he didn't receive it. He, who is the recipient, states he did receive it. So who would we?
He's never indicated that he has received it. Never.
But there should be synergy, so to speak. His affidavit should have mirrored your affirmation. The fact that you're making legal arguments on information and belief, where he should have said on personal knowledge, that's not my business address, or whatever people do when they want to trigger a traverse. That was not done below. The fact that you creatively submitted an affirmation raising the issue of service doesn't get him off the hook here.
Perhaps. However, it's still the burden of the plaintiff to establish actual knowledge in this particular case. It's their burden. It's not the burden of the defendant to prove that he did not receive notice. They are the ones that are asking for the contempt.
Thank you.
Thank you. Thank you.
Scottsdale Insurance v. City of New York.
Good morning. My name is, I'm losing my voice. Sorry. Good morning. My name is Ann Odelson. I'm with Kennedy's and I represent Scottsdale Insurance Company. This is a DJ action where the city is looking for additional insured coverage under the Scottsdale policy issued to Prude. Really briefly, there was an accident that occurred on the Upper East Side. Prude and some contractors were
Yes,
working.
counsel, we're aware of the facts.
So briefly,
So the issue is whether or not plaintiff owes the city a defense, right, in that underlying negligence action.
So Scottsdale's been defending the city under reservation of rights. City has its own independent counsel. We've been paying for the fees. We're not controlling the defense. All on the city. We're still continuing, obviously, to provide a defense. There's 2 additional insured endorsements contained in the Scottsdale policy. Both of those additional insured endorsements require contractual privity.
Well, the issue is whether the permit, which you arguably challenge, because the permit is clear that the city had to be added as an additional insured to the policy. You don't dispute that, do you?
Yes, we dispute that the city had their insurance procurement requirement in it. The only thing that was produced was a contract between Prude and the MTA.
Permit didn't require the contractor to name the city as an additional insured?
No, there's nothing in the permit that required it. We did a DJ action based on a contract with the MTA, basically saying there was no privity because Prude and the MTA entered into the contract. The city answered the complaint, asserted as a counterclaim, no. There's a permit, and there's a permit application, and that permit application
Doesn't the permit require compliance with Department of Transportation rules, and the Department of Transportation rules required the city to be an additional insured?
So the permit has general language
The
regarding.
permit says shall comply with all applicable laws, rules, and specifications of the New York City Department of Transportation. Those applicable rules require providing coverage to protect the city and Prude from claims for bodily injury which may arise from any operations performed by the applicant. And by providing that the city and officials and employees are additional insureds.
And before you get the permit, don't you have to somehow provide proof to the city that you have that particular insurance?
Well, they're relying on a certificate of insurance, which this department has held at other departments. It's not evidence of insurance, but just going back to that language doesn't specifically, and as this court is held, it's got to be specifically and expressly. I dispute that the contract, the permit is a written contract as required by the endorsement and the permit application.
It isn't
but-
just part of all the agreements, and we look at all of them together.
But there's nothing on the face of the permit or this permit application, other than that language that the justices pointed out, that's there, but it doesn't specifically.
Well, what's wrong with that language?
It doesn't say anything about incorporating, which this court has held, incorporating insurance procurement requirements. That has to be specifically stated in a written
So
contract.
you're stating that providing that the city and its officials are additional insureds, to have insurance providing coverage to protect the city, you're stating that that is somehow ambiguous, or?
I'm not saying that's ambiguous. That's not stated in that permit. That makes a general reference to rules, but that general reference doesn't talk about the procurement of additional insured status.
So the fact
highway
that it
rules-
says shall comply with all applicable laws, rules, and specifications of the New York City Department of Transportation, that does not in any way cause you, or you, that doesn't mean that you then have to make a determination or check to see exactly what the laws, rules, and specifications of the New York City Department of Transportation are?
Well, disputing that that's a written contract as required, because a permit is not a written contract, but the highway rules that do contain that additional insured requirement, those have to be specifically referenced in the permit, assuming that it's a written contract under New York law. Insurance, if you're going to incorporate rules or regulations, that's got to be specifically referenced in the actual document. So here it's not. While it contains that general language, there's nothing specifically and expressly incorporating the highway rules into this permit.
Isn't it true that Prude actually named the city as an additional insured?
No, there's a certificate of insurance, but
believe
that
there-
doesn't confer coverage, but then I go back to the requirements of
Prude
the insurance.
itself named the city as an additional insured,
I'm sorry, are you based on the certificate of insurance that says?
as a fact.
That's information only, and so the city is, the certificate we're saying is not, that's what New York courts have held, it's not evidence of insurance. But if you go back to, it's the written contract requirement that provides
Isn't
that
it at least an indication that your client understood that the city of New York had to be added as additional insured under an indication.
I would say it's not evidence. I don't know what Prude agreed to because there's nothing, even with all the documents that the city provided, showing that Prude agreed that that was incorporated, these highway rules were incorporated into this permit. There is a contract with the MTA between Prude that contains insurance procurement requirements, but nothing to do with the
You have
city.
time on rebuttal. Sir Counsel, what is your response to your friend's arguments that somehow it wasn't incorporated, there was no knowledge?
This court has held that the incorporation, the statement in an agreement that a party shall abide by all applicable laws means what it says, and it incorporates the requirements of those laws into the agreement. And so here, the bold-faced requirement in the permit that the permittee comply with the DOT's rules means that that the DOT's rules governed the agreement that was allowing Prude to rip up the roadway and occupy the public roadway, and that requirement was one of those requirements was that Prude obtain additional insured
But you
coverage.
do agree that the permit, right, does not stand alone in terms of a contractual agreement, right?
Well, actually, the city's position is that the permit is sufficient because it sets forth all of the terms of the agreement, and it was accepted by Prude, and so it standing alone, the city's position is that it is an agreement on its own, but certainly in conjunction with the permit application where Prude is asking, to be allowed to do these various things and under these various circumstances, and so is demonstrating, certainly taken together, they are a manifestation of mutual understanding of the rights and responsibilities, and thus is an agreement.
Would you agree that Prude, as the insured,
Yes.
paying the premium,
Yes.
will instruct the insurer, your friend, please add XYZ as an additional insured, correct?
Yes,
And just bear with me, and there's no privity of contract between the insurer and those being added as an additional insured. Would you agree in typical construction contracts?
Well, I think that the privity, my understanding.
I understand. So my point is this is routinely done. So the fact that Prude instructed the plaintiff to add the city as an additional insured, and then they get a certificate of insurance, which memorialized that instruction,
Yes.
put them on notice, and they're on the hook to be able to cover you as an additional insured.
Yes, that is definitely the city's position, is that, it's definitely clear that Prude's understanding was that they had obtained additional insurance on behalf of the city, and that was the purpose of providing the city with this certificate of insurance, to demonstrate that it had complied with the law. The law that requires the additional insured coverage, it demonstrates a legislative judgment that the city should always, whenever somebody is ripping up a public roadway, it should provide insurance protection for the city, and so it's difficult to see how the Scottsdale is arguing that this is not a requirement of the permit, that this is not a requirement of the agreement.
Briefly,
What do you do about this? Where does the certificate of insurance fall in terms of your position?
it's not evidence of coverage. This is what this department has held, and the second department has held it's not.
The certificate of insurance makes reference to the policy number, which is the policy number under which you are litigating now. And that certificate of insurance says that the city is an additional insured. And that is exactly the policy that you're litigating under right now,
So
which does not list the names of the additional insured, but say, these are the additional insured. So,
Yes, but on the top of it, it also says it's not evidence of coverage. So then it goes back to Prude paid money for a policy. What does that endorsement say, regardless of the certificate of insurance? There's two endorsements that require a written contract or agreement. And this court and other courts have repeatedly held where the written contract does not specifically state you have to get insurance.
but now when we go to the agreement, when we look at all these documents in conjunction, don't we have an agreement between Prude and the city that the city would be an additional insured?
No, because the endorsement specifies a written contract or agreement between the city and Prude. And even if there's case law from this department with this privity requirement, I can enter into a contract with somebody and I can say, list all of these different additional insureds. And I can come to court with an addition, a certificate of insurance saying somebody got this insurance. But this court has found in Linarello and other cases, because of what the actual endorsement says in the Scottsdale policy, there's got to be privity. Even if the contract requires me to get X, Y, and Z, if I didn't enter into the contract directly with that party, they're not entitled to coverage. So it's what the endorsement says.
17 Trust and Vicky Cornell, VIR Construction.
Thank you and happy Thanksgiving.
Take care. Yes, thank you. Proceed.
Thank you. May it please the court, Brian Ginsberg for the defendant's appellants. 2 points on this appeal are undisputed. Number one, Supreme Court applied the relation back doctrine sua sponte. And number two, sua sponte application.
But the arguments that would go into relation back were set forth, were they not? But I want to ask you about something else. Is what's happening here is we have the relation back doctrine being used to add another plaintiff to the existing plaintiffs. And the plaintiff that's being added, the statute of limitations has elapsed on their claim. Where does the relation back theory get utilized to allow one plaintiff to add another plaintiff? Isn't the relation back theory usually utilized? You've got defendants named, you left out a defendant that should have been named, and you use the relation back theory because they're united in interest perhaps, then you get that additional defendant back in. But here we're getting an additional plaintiff back in.
That's right, Your Honor. This is not one of the more conventional uses of the relation back doctrine. And frankly, in our view, that only compounds the error that Supreme Court made.
Did you raise this point? Did you raise this point in your brief to us?
In the brief to you, we acknowledge that this is a new plaintiff case as opposed to a new defendant case. And then we set forth the elements of relation back that apply that this court and the Court of Appeals have acknowledged in so-called new plaintiff cases. And we have shown how plaintiffs have failed to meet their burden in establishing.
I think my colleague is referring to some type of prejudice to you. So did you, in your papers, raise any argument that the application of the relation back doctrine would somehow be prejudicial to you?
Oh, yes, absolutely. We raised those in this court, of course, because below we didn't have any notice that relation back.
Well, first of all, you're adding a party whose claim has time barred. By what's happening is that a parties whose claim has elapsed under the statute of limitations is being added to be an additional to have a claim against you.
Exactly.
Counsel, I want to clarify what my colleague has raised here. Subrogation action means that it's not an additional party. They're stepping in the shoes of the plaintiff so that they're seeking to be reimbursed for the money they expended to the insured in this case, correct?
Yes, that's right.
So liability doesn't change here. And as you know, you didn't challenge the facts of the liability is not at issue here. And it's just a question of, do we pay the plaintiff or do we pay Greater Northern?
No, Your Honor.
So just let me finish what I'm trying to raise here. In terms of prejudice, The money doesn't change, it's who you pay it if you're ultimately found liable here under these circumstances for the construction that went south. So that, and that's the logic, and you can't say that they don't say, and they didn't say in their papers, we're dealing with the same facts and circumstances, the exact same transaction, the same period of construction that caused the leaks, et cetera, et cetera. All Greater Northern is doing is they're coming in to say, okay, we're going to step in your shoes, we paid you, and now, if ultimately liability is determined at the end of the day, we will be paid as opposed to the plaintiff. That's not a double recovery. That's absolutely not prejudicial. So where's the prejudice here?
Your Honor, before I have to sit down with the red light, I would like to explain that the money is not the same here. There is prejudice for two separate reasons. Number one, the Fourth Amended complaint adds a new demand for damages that's, quote, on behalf of Great Northern. That is separate and apart from the existing demand for damages that is on behalf of the
But they
trust and
can't,
Mrs.
they
Cornell.
would not be entitled, if they were paid, they would not be entitled to get a double recovery. You know that.
That's right, Your Honor, but that...
And you would get a credit or offset against any differential.
That's exactly right, but we would get a, we certainly
But
would
they're
get...
too late to make that claim now. Yes, it may, if they had been timely, then it's a matter of subrogation. But plaintiff cannot recover from the defendants that which GNIC paid them. So now GNIC is coming in to seek recovery of what it paid when it's too late to do it anymore.
Your Honor, I agree with that. I also want to make the point that as we read the Fourth Amendment...
Counsel, isn't there a case that's right on point that says that even though we normally do not permit another plaintiff to come in, when it's a subrogation action, that is a different story. Under McHale versus Anthony, that's exactly what happened, because what my colleague said, he's stepping into the shoes.
That's not what happened in McHale versus Anthony with respect, because in McHale, there's no dispute that the essential element, what the Court of Appeals has called an essential element of a subrogation action, which is payment of the insurance claim by the insurer, was notified in the prior pleading. There's no indication in McHale that that was in dispute. Here,
Put that aside, but I'm talking about the concept of permitting subrogation action for another plaintiff was validated in McHale.
It can be done, Your Honor, under...
That's what I was trying to say.
Yes,
I'm not saying it's on exactly on point of these facts. I'm giving you the legal theory that a plaintiff may be introduced into the action as a new plaintiff because it is a subrogation action, even if it's time barred.
And stated at that
by
level...
relation back doctrine.
Yes, it's stated at that level of generality. I agree. Our point is, and I hope to get into this more in rebuttal...
Yeah, Counsel, I wanted you to get into your point. My colleague mentioned it's not going to be a double payout, and you started to say something. What was the second thing you wanted to say?
Yes, thank you, Your Honor. Under the third amended complaint, which is the prior complaint, I certainly agree that we would have had an offset because the only plaintiffs were the trust and Mrs. Cornell. So if we were able to show evidence of an insurance payment to the insureds, who were the only plaintiffs then, we could have used that as an offset. Now, however, that offset has been turned into a liability by the way the demands in the fourth amended complaint are structured. Now, if you take my friend's theory on the other side, that this is just a reallocation of the amounts prayed for that have already been there, now there's an allocation to Great Northern of the amount of damages that's covered by insurance. That's the $1 million plus. So we don't have that offset anymore because Great Northern is the party requesting that, and Mrs. Cornell and the trust are now, at least if you...
But that still would not result in a double payout.
It would result in a $1 million plus additional payout than would have been permissible under the third amended complaint, because by virtue of the party asking for those damages, because it's now Great Northern that's asking for that $1 million as opposed to the $1 million being subsumed within the trust and Mrs. Cornell's request, we can't get that offset. And that offset has been turned effectively into a liability because Great Northern is asking for it.
Yes, Justice Hagler?
Yeah. So I think you're making this too complicated. This is simple. The allegations are that there were certain renovations that were done in a faulty manner, and as a result, there were damages. Whatever those damages are, the damages remain, whether it's paid to GNIC or it's paid to another, and it doesn't matter. That will be resolved at trial as per the damages. The offsets will come. So it doesn't matter whose pocket it comes from. Let's say it's $3 million is the total amount, and $1 million went to GNIC, so that gets reduced off the top. So obviously the plaintiff can't recover, as my colleague said. So you're conflating the damages. You could only recover so much as the damages are proven at trial. And if there was a $1 million payment, then it doesn't obviously go to the plaintiff. It gets reduced.
Your Honor, our position is, and I thank you for the court's indulgence in allowing me to go a little beyond my time, our position is if indeed plaintiffs are asking for the same aggregate dollar amount in the third amended complaint as they are in the fourth amended complaint, which we don't agree with, but if indeed they are doing that, then because of how they are divvying it up in the fourth amended complaint and strategically allocating the covered damages to Great Northern, whereas before they were all prayed for on behalf of the trust and Mrs. Cornell, that offset, I mean, your words are music to my ears if that's the case, but on our view—
I saw him nodding his head, yes.
Well, I'd love to get that in the record too, Your Honor. But in our view, as the fourth amended complaint, which is the only verified pleading that we actually have here to deal with, is structured, though that $1 million of damages that are covered by
No one's saying you're precluded from making that argument, even if there's an amendment, right?
I mean, that's how we read the fourth amended complaint.
This is only an amendment. There's no preclusion of how you try the
That's
case.
right.
So this doesn't preclude your determination. If the amendment just says that it moves forward, and then the damages remain the damages. I've concluded my.
Yeah, I
Thank
mean,
you. Yes, you do have time on rebuttal.
Thank you, Your Honor.
Thank you. I appreciate that.
May it please the court, Robert Phelan, introducing Kyle Rice Prohock.
May it please the court, Kyle Rice on behalf of plaintiff respondents, and our position is exactly has been raised already. There's simply no prejudice here because this is not a new party. A subrogation action is an action where a party simply stands in the shoes of its insured and has no more.
What about your friend's argument that now it's going to cause an additional $1 million payout?
We fundamentally disagree. The addendum clause from the beginning of this case had minimal damages of no less than $2 million in special, no less than $3 million in compensatory. So it set a floor, not a ceiling. And so first off, we disagree that it even increases exposure just based on that alone. But second
Are you
off,
conceding that you're seeking no damages different than those you sought in the third amended complaint?
that we
Oh, that's a yes or no question.
can you sorry, can you repeat the
Are
question?
you conceding that the damages you're seeking via the Fourth Amendment complaint are no different than the damages you're seeking in the Third Amended complaint?
They arise from a 2019 water loss, and that amendment was in 2020, so they would be encompassed in those same damages. So it is the underlying transactions and occurrences here.
Is that a yes?
That's a yes. All the underlying transactions and occurrences occurred from a construction project from 2014 to 2017. And this water loss was discovered in 2019 due to a staple in the radiant heat flooring traced back to that construction project. So all of these claims arise from the same transactions and occurrences. The exposure is no different. CPLR 1004 also allows an insured to sue, or insurance carrier to sue in the name of the insured. There's quite simply, there's no new parties, there's no new transactions and occurrences, there's no new prejudice. Well, it's a new party effectively in name only just by the nature of subrogation.
Isn't that McHale?
That's exactly what happened in McHale's, Your Honor. May it please the court, we ask that you uphold the Supreme Court's ruling.
Thank you.
Thank you, Your Honors. Just a few brief points in rebuttal. I think we have to agree to disagree on how we read the Fourth Amended complaint, but in summary, it matters not only the amount of damages prayed for, but who is praying for them. The fact that the covered damages are now allocated to the plaintiff Great Northern prevents us, as we read the Fourth Amended complaint, from taking the offset that we otherwise would have been able to take. Justice Hagler, you wanted me to try to make this case simple. I think here's the simplest way to think about this case. Supreme Court applied a non-jurisdictional defense sua sponte, and this court has said, including as to relation back specifically, that the application of such defenses—
To be fair, they didn't use the word relation back, but didn't they say it's the same transaction occurrences, which is the same thing as saying relation back doctrine?
That's not the same thing as saying the relation back doctrine, Your Honor. In fact, in their papers at pages 150 to 152, after we raised our timeliness objection, they didn't even use the word timeliness, let alone relation back. And as evidence of that, that's why we didn't make flesh out below the arguments about notice and mistake and prejudice and the like that would have been on the table, that we would have known would have been on the table had plaintiffs actually raised this properly. And again, this is not...
When counsel said that he agrees the damages sought in the Fourth Amendment complaint are no different than those sought in the Third Amendment complaint, that does not satisfy the issue you raise?
It doesn't satisfy the issue I raise, Your Honor, because it's not only the amount of damages being requested, but which plaintiff is requesting them. And on our read of the Fourth Amended complaint, because the damages covered by insurance are now, unlike the Third Amended complaint, they're now being requested by Great Northern, that offset that we otherwise would have been able to take under the Third Amended complaint has been turned into a liability. And Your Honor, this case is fundamentally different from McHale and the other, actually I think that's the only subrogation case that my friend on the other side cites, because plaintiffs who had the burden, whatever else is true about prejudice, plaintiffs have the burden on proving notice, and there is no dispute here that the Third Amended complaint did not notify defendants of what the Court of Appeals has called an essential element of a subrogation cause of action, which is the insurer's payment. So we would respectfully ask for reversal, Your Honor. Thank you.
Thank you.
Thank you.
Buckley v. Hearst Corporation.
May it please the court, Your Honors. My name is Scott Singer, and I represent the plaintiff appellant in this matter. This is not a case like Gasquez that was tangentially related to the effects of
How
gravity.
about Harnish? Is it a case like Harnish?
Harnish?
Harnish.
I don't know.
Harnish v. City? Harnisch. I think I'm pronouncing it correctly. I know myself and Justice Friedman were on that matter.
Okay.
Bless you.
I don't recall the case offhand. So.
Well, in this particular case, so how was Mr. Buckley engaged in any work covered by the labor law when injured?
Oh, you're talking about the Pratt's issue, whether he's entitled to the protection of the labor law.
Yes.
Yeah. It's
because
really,
the Supreme Court dismissed the 241, the 240 subsection 1, right?
That's correct, but it left in the 241-6.
I'm sorry?
It left in the 241-6 case, the claim. This is, to me, this is under Pratt's, it's the easiest question to answer because there was a contract. This work was part of the contract. It was an integral part of the contract. The building representative acknowledged that it was part of the contract.
But the work was done. This wasn't a punchless case.
Well, the work is not done until the work is approved.
No, but that was my point. Again, in order for there to be coverage under 240 subsection 1, he has to be engaged in some type of work related to the labor law, work related to the construction, et cetera. He is there with someone else. There's no ongoing construction being performed while he's injured. He's just there inspecting the facade. The work on the facade had been completed.
The work on the facade had been completed, but they still had to examine it to determine whether there was other work that needed to be done.
So Harnish and a whole line of cases talk about the fact that inspection where work has been completed does not fall under Labor Law 240 subsection 1.
For one thing, the work was not completed. There was testimony from the window washer that was operating the scaffold that the work on the parapet on the roof of the building had not yet been done.
Was he not inspecting the facade with someone else at the time of the incident?
He was inspecting it with a representative from Vidaris, the
Right.
company.
Was there any work still being done on the facade?
There was work that was going to be done as needed. This was the
at
first
the time, not as needed, not in the future. At the time, was there any work which was being done?
As I understood the plaintiff's testimony, he was saying that there was some work being done to repair the trim as they proceeded, and it was supposed to be done. And there was no way of knowing whether additional work was needed unless they performed this inspection.
So have we ever said that work to be done in the future would constitute ongoing construction? Work which possibly is going to be done in the future is going to constitute ongoing construction work or ongoing work which would fall within Labor Law 240 subsection 1?
I don't know why that's not resolved by the Pratt's decision. The Pratt's decision was an inspection. It was an inspection done after the work was essentially done, but it was necessary. It was an integral part of the contract work. It was the same contract. It was not not like in being a distinct part that was easily separable. It was the same contract, the same work.
Wasn't it, as my colleague made reference to, wasn't it just like a checkoff in terms of what was done, what had to be perhaps done? In that case?
The work is not considered done until this inspection was done because it was specified in the contract. It had to be done. That was the way the only way the contract could be fulfilled, and I don't know any case that suggests otherwise in this kind of circumstance.
So in Pratt's, it was whether an inspection is covered depends upon whether it falls under a separate phase easily distinguishable from other parts of the larger construction project or occurs during the ongoing work.
Precisely, that's the standard. This was not a separate phase. It was the same place, it was the same facade, it was the same BMU that was being used for the other work. It was not a separate phase, and they anticipated, and I don't know what eventually would have happened, they anticipated that there would be additional work. In addition, as I said, there was testimony that there was work.
The plaintiff said that he was there merely to answer questions. He was there to answer questions during the inspection by the consultant.
And to perform work as needed on the job. And
That's not what he said.
Yeah, yes, to perform work as needed. And this was confirmed by Mr. Lowenstein, by the way.
His testimony was that he was there to answer questions during the inspection.
And if work was needed, he would perform it. And Mr. Lowenstein, Adrian Lowenstein, who was the inspector, said yes, they would do the work on the job. Thank you, Your Honor.
Yes, you have time on rebuttal.
Good morning, may it please the court. Jonathan Schaub for the defendant respondent. The court's exactly right. This case is not, the work was done. It was a separate phase of the work. The testimony is very clear about this. The PNA, the foreman and the superintendent who was in charge of this work said the work was done.
I thought that I thought that everyone conceded that all the work had been completed.
All of the work had been completed, so that's what takes this case out of Pratt's. In Pratt's, the work was ongoing. The construction work was continuing. And in fact, if you read Pratt's closely, the work that was being performed at that time wasn't even an inspection. They were preparing the work for an inspection. At the time of this accident, the plaintiff was with a third-party inspector. The work had concluded in mid-November, and everybody who testified on this record said that the work was completed. Plaintiff himself conceded that the work was complete. So this case is more of the Boehner case in that the construction work and the repair work was performed, and then afterwards there was a post-repair inspection. And the Court of Appeals was very clear in those circumstances that that is not there's no enumerated activity happening here. There is nothing that can change those basic facts of the case. Harnish says it, Boehner says it, and Pratt's doesn't apply because it's an entirely different factual set of circumstances. Even the window, even Mr. Lowenstein, who was the inspector, said he was there, the plaintiff was there to answer questions. There is nobody here who said that this work was to continue. And because the work was done, there can be, it's a separate, independent,
So counsel, let me stop you. Isn't it true that Mr. Lowenstein stated, and it's on page 2536 of the record, in the event they needed to perform additional remedial work, a representative of PNA had to be there ready to do so while we were on the job.
And then I think he clarified that testimony as it went on, and he said that he was asked several other questions, and the question was, no, they would have to prepare
Correct.
work order, they would have to take it.
So what you just said was that there was no work that had to get done. Right. Maybe at that very moment while they were on the BMU, there was no work to be done, but certainly there was an expectation that possibly in the future work would have had to be done if they identified in the inspection some caulking or some other item that needed to be repaired as pursuant to a punch list.
Sure, but that can't be the case that would then trigger Labor Law 240 liability.
Why?
Because under the Boehner decision, the worker was performing post-repair inspection. He wasn't going up there just for the sake of it. He was going up there to see if something else needed to be done.
You're saying Pratt's is
Pratt's
not...
is distinguishable because the work was continuing and the worker was toggling between assignments. It wasn't as if the work on the air duct units and all of the other AC repair work.
You're saying if there's a total stop of work.
I'm saying, whereas here, the record reflects that the work was completed. That's by the plaintiff's boss.
I think everyone said that.
Right. So then,
except for we just heard today.
Right. So in that sense, then that is done, and then that takes it into the Boehner land and takes it out of the Pratt's land, and the Court of Appeals decision controls on that.
In our case in Harnish, where he was inspecting the billboard.
Exactly. So unless the court has any further questions, rest on our brief and wish everyone a happy Thanksgiving.
In Harnish, the court said the inspection was not done during any ongoing construction project, but was merely investigatory. This was investigatory. This was work that had to be done under the contract, pursuant to complete that contract. And as I said, there was still work that hadn't been completed. So we don't even know the extent to which this was repair work, specifically repair work. And it was being done, and the job could not be done unless this was done. And
so you're saying the contract requires that after repair, there will be inspection and there will be a punch list items to be repaired. It's one contract, you're saying, and one job.
And Karen Montero, their representative, acknowledged that it was pursuant to that very contract. This is not a case like Boehner, where there was, in Boehner, the plaintiff went up to the roof after the work had been done to check on a serial number.
Was that work pursuant to a contract in Boehner? The same contract?
There's no indication it was a contract at all. They called.
Was it pursuant to the same job?
It was related to the same job.
So why isn't it on all fours?
Because it was a different place, and it was different equipment, and it was a different time. This was while work was ongoing. It was while using the same BMU on the same facade, exactly.
What work was ongoing?
As I mentioned, there was work, the parapet hadn't been completed. The work on the parapet.
Where's that within the record?
That's in the testimony of the gentleman that was operating the rig.
Thank you. Thank you both.
Thank you, Your Honor.
Thank you.
Aroa Corporation v. Cookman Best Insurance.
Good morning, Your Honors, and may it please the Court. Unless you have questions for me, I'm happy to yield my time, given that appellant didn't show.
You said you wanted 3 minutes.
It was only, honestly, to basically, just in case he did show.
Thank you. Have a
Thank
happy
you.
Thanksgiving.
Happy Thanksgiving to you too, Your Honors.
Valley National Bank v. Community Protestant Church.
Good morning, Your Honor. Gerard Riso for Plaintiff Appellant. Your Honor, we've lost 2 summary judgment motions that were appealing from the orders of the lower court. In both instances, the lower court raised sua sponte evidentiary objections to the mortgage and note itself. Those objections were not raised by the respondent. In fact, the respondent did not even oppose the initial summary judgment motion. The court on the re-argument motion raised sua sponte additional evidentiary objections that the respondent had not raised on authenticity grounds. Both of those evidentiary rulings, even though they should not have been raised sua sponte by the court, they also defied the record, and they were both wrong as a matter of law. For instance, in the first summary judgment motion, the lower court on its own made a determination that appellant had failed to lay a business record foundation to the admissibility of the mortgage and the note on the summary judgment motion. The court erred because the mortgage and the note are not hearsay documents. They are legal agreements that create legal rights, and of course, they're not being offered for the truth, they're being offered to create the legal relationship and obligations and rights of the parties. This court has made that finding expressly in the global case, other courts have said. It's simply not a novel concept that the mortgage and note are not business records. And because they're not business records, the bank was not required to establish a business record foundation. Also, Your Honor, aside from the respondent not objecting to it, the respondent in its answer also relied on the mortgage and the note in framing at least two of its affirmative defenses, which were essentially, we paid or they didn't properly credit the mortgage or the note, therefore we don't know what they say we owe.
There was no serious challenge to the officers of the church signing the forbearance agreements, correct?
Correct, Your Honor. In fact,
And the forbearance agreement more or less incorporates or acknowledges the existence of the mortgage and a note and the consolidation.
it does. It absolutely is an acknowledgement that we are the holder of the mortgage and the note. And in fact, when we served the request to admit, when we got those responses back, those responses to the request to admit were verified by the very corporate officer who was involved in the forbearance agreements. All of those requests to admit admitted that it appeared to be the signatures of our officers. That's a clear admission. They're not disputing it when you say it appears to be our signature. Plus, of course, CPLR 4538, there's a certificate of authenticity, a certificate because of the acknowledgments to the mortgage and the note. There's a presumption under the statute that the person who signed it, in fact, signed it. They did nothing to rebut in any way that presumption. We proved the mortgage and the note. We proved the default. They admitted the default. Counsel admitted the default in two of his affidavits that he submitted to the court.
This isn't a homeowner's loan, right?
Correct, Your Honor. This is a commercial mortgage proceeding.
So they don't have any right to special foreclosure hearings as a typical homeowner would under these circumstances.
Correct, Your Honor.
Even though they're a non-for-profit.
Correct, Your Honor. And we asked that their affirmative defenses which invoked those sort of home consumer statutes be rejected for those reasons. So, Your Honor, we believe the lower court made evidentiary rulings that it shouldn't have made sua sponte, and they were just incorrect as a matter of law. One of the other things the lower court said in the second ruling was, okay, I concede, the judge in effect said, that I was wrong when I said you needed a business record foundation for the mortgage and note, but you still need one because you're relying on the records of a predecessor bank, and you're trying to incorporate those records into as part of your records. But we're not trying to incorporate any business records of the Westchester Bank. The mortgage and note are not business records, even though we got it through a merger and the Westchester Bank no longer exists. They merged into us. We produced the merger agreement. Under the merger agreement, all of the assets of Westchester Bank became the assets of Valley. There was no business record of Westchester that we needed to establish the admissibility of the mortgage and note because they were not hearsay documents at all. Your Honor, I have nothing further unless there's any questions.
Thank you. You do have time on rebuttal.
Good morning. May it please the court, Hugh Campbell for the respondent. Your Honor, it is clear that the court below was correct in denying the motion because I think counsel basically is confusing authenticity of the documents with admissibility. And I think what the court basically said that they had not laid the proper foundation. Now,
did you object, or did counsel object to the admissibility of those documents?
Of the
On the first motion.
On the first motion.
On the first motion, no, because technically what happened on the first motion, we had made an application to the court for an adjournment, and there was no response either way as to whether the application was granted or denied, and then a decision came out.
But it was submitted on basically without opposition, so there was no objection.
Well, no, that is true because the judge made a decision before he ruled on whether or not the adjournment was being granted. So we had no opportunity to interpose opposition with respect to that motion.
So was it proper for the court to have done what it did?
Well, absolutely. The case law is very clear that they have they had the burden of proof on a motion for summary judgment. They had to basically.
But then you raise issues that raises to the admissibility of various documents. Had it been raised, they would have had an opportunity to reply to it, rather than if the court sua sponte makes a decision finding objections to these documents which were never raised, and they never had a chance to respond to.
Well, no, the court does have an obligation as a gatekeeper to follow the law. And in essence, if indeed the plaintiff did not meet their burden, then the burden does not shift to the defendant. And theoretically, that's basically what we have is a shifting of the burden to the defendant to authenticate and to verify the admissibility of those documents.
There's a note in mortgage submitted in support of the motion, and then the court says, well, this is not admissible. On what basis?
Well, they submitted a mortgage.
Without them having a chance to explain.
They did not submit the original mortgage and note. As a matter of fact, there's still a question as to where the original mortgage and note is. What they submitted were copies, and in essence, the court said that you have to come in.
Well, had someone raised an issue about it, they could have in reply said, well, here is the original.
Well, the original is in the custody of the...
They have them, right?
No, and they made a second motion. And even when they made the second motion, that's the original was still not presented on the second motion.
Doesn't this just underline the problem of having sua sponte raise this objection?
Well, the court has the authority to raise the issue sua sponte on, that's the court's prerogative, and the law supports that theory. But in essence, what we saw was two successive motions. First motion.
So, counsel, I've never seen an original mortgage and note in any motion for summary judgment, and you've been before me. And generally, what you do is you put in the papers, and the lawyer says this is what it is. And if there's an issue as to the authenticity of the document, then the court may require, as my colleague said, to bring in the original if there's some challenge to the authenticity of those documents.
That is correct. And as raised in the affirmative defense in the answer, they were not a holder in due course. And then now the obligation...
That's a standing issue.
Yes. Now the obligation shifts to them to show that they were a holder in due course, and they never did that because they never...
Counsel, can you answer my question? When on a motion for summary judgment is the original mortgage and note ever supplied to the court? As a matter of fact, it's e-filed.
It is never submitted. However, someone comes in and states how the record is kept, where the record is kept, and indeed, this is a true copy of the original. That was never done in this case.
I think it was.
No, it was not, because the person who did it did not have, they had no personal knowledge as to the...
So counsel, your argument is valid, what you're saying. However, it was done. You're just saying that the individual doing it was not the proper custodian.
That is correct, and that's why the court denied the motion.
Is that what the court stated, that they were denying the motion because they weren't?
Well, that's amongst one of the reasons, because in essence, they basically said that the records that were submitted were not properly authenticated, and in essence, both motions were denied.
Would you also agree that the first, fourth, and fifth affirmative defenses are invalid? It's not a home loan. 349 is not triggered.
That's correct.
You agree with all that?
That's correct.
And you don't challenge the signatures?
Well, Your Honor, if you read the notice to admit that was subsequently submitted, if you notice, those notice to admit barely states that they were done up in information and belief, and specifically in the notice to admit, it also stated that they could neither admit nor deny because the original signatures are not, because the signatures were not attached to the documents. So you cannot admit or deny something where just the documents are submitted and they're not signed.
Thank you.
Thank you.
Yes, briefly, holder in due course is irrelevant. What's important in a mortgage foreclosure is that we're a holder, and we establish that we're a holder. Holder in due course just says what defenses you're immune from or not.
Isn't that traditionally with commercial paper? I mean, mortgage is a little different than typical commercial paper, right?
Correct. And there's never, I've done many foreclosure cases, there's never been a situation where we've produced a note, an original note or original mortgage. The mortgage in any event is recorded, and we put in as an exhibit the recorded mortgage. They admitted in their answer when they relied on the mortgage and the note for their affirmative defenses. That takes authenticity out of the case. And of course, CPLR 4538, there's a presumption and nothing was ever done to rebut that presumption because the mortgage and the note were duly acknowledged.
Thank you.
Thank you, Your
So,
Honor.
Thank you.
Out to Morano v. Frick Collection.
Good morning. May it please the court, Michael Cassell. I represent the defendants appellants in this matter. This is a label or 240 and 241 case. As we set forth in our papers, for 3 separate reasons, the lower court erred in granting summary judgment as a 240, any one of which would provide a basis to deny the motion for summary judgment.
Why wouldn't a ramp be an elevated related device?
Well, for 2 reasons. One, we have an issue of fact as to the height of this ramp. And secondly, there is case law from this department that says when a ramp is used as a passageway and solely...
It's not a passageway. It was a tool to be able to take the cart of debris from the 2 buildings. It's a tool. It's not a passageway in that context.
Well, there was testimony that was used to go from one side of the building to the other side of the building. It was
The
used...
testimony was that was the purpose that the ramp was installed. It was for that, that was the purpose. It was a tool for, again, transporting from one building to the other building. So it's a safety device.
We do cite cases, I believe they're from the second department, that does say that when a ramp is used in this type of manner, it could be deemed a passageway, or at least a question of fact as to whether it's a passageway.
No, I don't think so. I think the Whitestone case makes it clear that a ramp used in this context. I think your issue more is in the context of the height differential concern, but a ramp in this context is clearly a device. We've so held it.
Okay, we also argue, of course, the height issue and...
This ramp, there's an excavation trench below it, is there not?
There's an excavation trench to the side of it, there
The
is.
side of it, and what's the height there? What's the fall between the ramp and that excavation ditch?
It's not clear, Your Honor. That's one of our main arguments. The height issue is never...
I thought it was something about 6 foot deep.
The plaintiff...
The trench was about 6 feet deep.
The plaintiff alleged he thought the trench was 5 to 6 foot deep. The actual trench, I think Ms. Torres said she believed it was at most 3 feet deep, but there's no actual measurements, just photographs that from the angle you really can't tell the height.
And you concede that the ramp is how high is the ramp? Is it 2 feet?
The ramp is well, the difference between the one side of the building and the other side of the building is 2 feet. It really wasn't crystal clear what the difference is between...
But anyhow, to get down to the scenario here, you've got a ramp which lacks a guardrail on it, stuff is being wheeled down this ramp, overlooking a ditch, which is whether it's 3 feet or 6 feet. Isn't it sort of apparent that you needed to do something to protect against a fall off of that ramp?
I believe our strongest argument as to that issue, Your Honor, would be the Salazar case as to whether or not at the time there was an actual mini excavator there. So if there's an issue of fact, we would at least as to whether or not we could have covered the trench during the ongoing excavation.
You're out of it because this is a mini container?
I'm sorry, what?
You say you're out of it because of the size of the container?
No, because there was an excavator there at the time. It was
Yeah.
actually doing excavation at the time.
The fact that the ditch was necessary for the excavation doesn't mean you couldn't have put a guardrail. That would not have required covering the ditch.
I understand the guardrail I understand there's also testimony from my client as to the guardrail, but the plaintiff's strongest argument here is that he gets past the height differential because his claim is he fell to the bottom of the trench, not that he simply fell from the ramp down it's not even clear, 1.5 feet, 2 feet to the dirt right below the ramp.
Does it matter if he fell off the ramp?
Well, it matters to the extent of the height differential, at least. His claim is he fell to the bottom of the trench, and certainly under this case law, if he falls 5, 6 feet to the bottom of the trench, there's no question at all as to the height differential. The argument by plaintiff is, I didn't just fall from the ramp straight down, because to me, there'll be a question of fact as to what that height differential is, because there's no testimony exactly, and this court has held that under 2 feet could be a question of fact. So,
Yeah.
Thank you.
Good morning, Your Honors. May it please the Court, Anthony DiStefano for Plaintiff Appellant, Respondent. Confusing myself. The testimony comes from their witness. I mean, their witness says that the differential between levels is 2 feet, and then the pit is 3 feet. And those are the defense witness's words. So the height differential here is at least 5 feet. And as Your Honor said, a railing would have prevented this accident from happening. He would not have been able to
Counsel,
fall.
don't we even have a picture of the trench and the plaintiff inside the trench? If you look at 272, we see that at least half the body is covered, so an average person, let's say 2.5 feet to 3. We see it in live. I have black and white, I don't have color. So we know that it was at least 2+ feet, and plus we know the ramp was 2, so we're talking 4 to 6 feet.
Yes, Judge, and that was what the witness used to give her estimate of 3 feet. So that's what a jury would hear. If there was some question of fact, a jury is going to hear at least 3 feet into the bottom of the pit, and then you have the 2-foot ramp, which is 5 to 6 feet.
And there's no issue that this was not a passageway, but rather it was a tool.
Correct. Again, using that witness's same words, that witness instructed them to build that ramp so that it could be used to transport these materials. And that was a tool that needed to be used.
Say nothing of the
work.
fact of trying to wheel that container down that ramp, which wasn't wide enough.
And then we get
presented an
into the
obvious
241
hazard.
sub 6, which I know Lauren addressed, but it's all laid out in our brief. If this court even needs to get there, because of course, if you grant 240 sub 1, then you don't even need to reach 241 sub 6.
Thank you.
Thank you.
I'll just respond briefly to one issue. I think there's a little bit of a disconnect between Ms. Torres's testimony. The 2 feet was her testimony between the one end of the ramp and one end, on the other end of the ramp, between the two portions of the building, not from the ramp to the ground below.
The pictures, the photographs show that there is a significant different, it's deep.
Well, I mean,
There's
Torres,
significant depth.
I don't dispute that Ms. Torres said that it would be at least 3 feet or 3 feet, she estimated, from the ramp to the bottom of the excavation pit. You know, I go back to the issue about whether or not the excavation pit could have been covered at the time of the accident. If there's no other questions, I appreciate your time.
Thank you. Thank you both. Board of Managers v. 1055 Madison Avenue.
Good morning. May it please the court, Reuben J. Ginsburg, Levin and Glasser for the plaintiff appellant. This case comes out of a condominium relationship with its commercial unit owner. The commercial unit owner who altered both the exterior and the interior of the building and its unit without the permission of the condominium, in direct derivation of the condominium's bylaws, and in fact, against an express warning not to do so by the condominium, leaving the condominium in a position where, according to its own experts, which have not been refuted, there's a current code violation with respect to access to plumbing.
Among the relief that the items of relief that you're seeking here is an injunction, right? A mandatory
Yes, Your Honor, as to
injunction.
two of our causes of action.
You want us to order on this, as a result of this appeal, that the sign be taken down and that perhaps the mezzanine should be rebuilt. What if the outlook was, well, yes, the sign shouldn't have been put up and the mezzanine shouldn't have been taken down, but it's not something that we should grant injunctive relief for?
Well, there's several issues there to unpack, Your Honor. With respect to the mezzanine, we didn't ask, the cause of action actually seeks two different types of relief in the alternative. This is our fourth cause of action. The first is to put back what was there, and Your Honor correctly cites that. But the alternative relief was just to restore access to the easement through any legal means. So right now, according to Ivan Pollock—
They haven't stopped access to the easement, have they?
Well, there is no access. It's many, many feet up in the air.
20 feet, about 20 feet.
Yes, and there's the fire hose, there is the water pipe system that services the heat and hot water for the whole building. And that is also the access to, there's a roof deck right off of that area, which now we'd have to go scale down, I presume, from some residential unit owner's window to get at. And the lower court based its decision, strangely, on the fact that we have a right of self-help under the bylaws. But this court has found long ago that under the Lassner case, that an adequate remedy at law has to be adequate and has to be a remedy at law. As to self-help, that's not a remedy at law. That's just, it is what it is. You do what you do and you take your chances that you're going to get sued because they don't like the means that we're utilizing to restore the easement, which they've made clear they're never going to give us access to. In their brief and throughout the record, they've made clear that they don't think they need to. But more importantly, in Lassiter, adequate was defined by this court. And adequate is a practical and as accessible remedy as a remedy at damages is, I'll quote just so I don't get it wrong, it's practical and as efficient to secure the ends of justice as the remedy in equity. Now, what the court left us to do, presumably, is A, get self-help, which they're not going to let us do. They've said so on the record. 2, construct a remedy to get there, which they've said is going to unduly interrupt the commercial unit owner, no matter which solution I pick. And by the way, Pollack suggested 3, but that wasn't an exhaustive list. Those are just the 3 he recommended. Now, they'll no doubt countersue and say, whichever solution I pick, it's unduly inconvenient. They didn't like the hours. I should have done it on the left, and I shouldn't have done it on the right. So self-help is not an adequate legal remedy. And further, it's not adequate because it doesn't provide us with anything. What it provides us with is a bunch of extra lawsuits. A lawsuit to get the access that they said they won't give us, a suit by them saying I used the wrong method to get to the easement, and then a suit by me to get paid for the reconstruction that they demolished. Turning to the signs, which Your Honor also pointed out, on the sign.
You initially did not object to the sign, right?
No, Your Honor, we did object to the signs. In fact, on 4 different occasions, and we wrote to them and said, you do it on your own risk. And most importantly, when we filed the complaint in this case, the sign wasn't up. On September the 10th, 2019, we wrote them, don't put up the sign. 2 weeks, 3 weeks later, we filed the complaint seeking a declaration, critically seeking prospective declaratory rights. And I'll point out, since this case has come to this court, more signs have become an issue. We wanted a prospective statement saying, you don't have sign rights. 5.7E of the bylaws doesn't give it to you. 9.2 of the deck gives us right to injunctive relief.
So why did the court deny the relief requested as to the signs?
As to the signs, the court found that balancing the equities, their interest in attracting customers outweighs my client's interest in mere aesthetics. But that ignores a few very
Well, was there also something in the record that there were no complaints by any of the shareholders, the individuals in the condominium as to the signs?
The court didn't mention unit owners objecting. What they mentioned is that in correspondence with the board, as part of a negotiation of a global settlement, we said we can live with the signs if we came to a deal on everything. And the court then tried to isolate, saying, well, since you were willing to give on that point, and even though the other side told you to pound sand on all the things they were supposed to give, you're still bound by your concession, but they're not bound by any of theirs. And so we're left in a position where the court wrote 5.7E out of the bylaws. The court said that because our concerns are aesthetic and their concerns are attracting customers, their ill-gotten gains.
The court also said that their concerns were also monetary, right? That it would be
well, of course, their concerns in attracting customers hurts their bottom line. But that means that the thou shalt not put up an external
No, but
sign.
also costly in terms of removing the sign as well.
I don't think the court found that it would be costly to remove the signs monetarily. Somebody can do that in a single day and it would cost.
You have time on rebuttal.
Thank you.
Thank you, Your Honors. May it please the court, my name is Ethan Cohen from Rosenberg and Estes for the respondent.
So your client would not allow an easement to them in terms of access?
No, Your Honor, that's not the case here. Here, the claim for an injunctive and declaratory relief has been brought 5 years after they removed the mezzanine and catwalk, or 4 years, and now it's 5 years. They waited that entire time. We sent them the plans that this was going to happen. They reviewed all the plans. They watched the work happen. They didn't bring any injunctive or declaratory relief to stop it, knowing the entire time exactly what was happening. They let it go for several years. And then they said, well, oh, now you need to buy us a scissor lift so that we can access it. And we agreed to buy the scissor lift. And they said, well, actually, you need to buy a bigger scissor lift. And now, 4 years later in this action, they're saying, actually, we don't need a scissor lift. We need some other solution that's going to cost more money.
There's a catwalk, right? Isn't there an issue in terms of a catwalk, and now that they can't access that?
It's a catwalk and a mezzanine that has
Right.
been changed. So they can they've not only can they access it, they have accessed it multiple times over the past 4 years. They have installed scaffolding when they needed to access it or had other means to access it. And they've admitted several times, even in their papers on this appeal, that they can still access it. They just want us to do their particular method of accessing it, that their expert came in after this case started, after they moved for their causes of action, and said, actually, what they're asking for isn't good enough.
But you didn't counter anything that Mr. Pollack said. Respectfully, there's no counter expert on your behalf that counters, for example, that the removal of the catwalk and mezzanine, which left the hose the way it is, was not a violation of the plumbing code, or that their inability to access the elements were not ongoing violations. You didn't counter any of that, sir.
Well, I don't believe any violations have been issued, and also...
No, but I just said something else. I didn't say
I'm
that.
sorry, I'll address that. So
I said the expert said these are ongoing, continuing violations. There's nothing on your side of the table that counters Mr. Pollack, yes or no?
I don't believe there's a counter to his expert opinion, but what I would say that counters it is that the court found, and we've asserted, if they actually believe this to be the case, they wouldn't leave it this way. They have a right to fix it under 11A of the bylaws and or declaration, and the court found they can do that. They can do that and get monetary relief for whatever that costs. If they actually believe that this is a violation and that they need to fix it, they can fix it and sue for the damages. Instead, they sue for declaratory relief that's actually injunctive relief, saying, declare that they have to restore the catwalks. That's not how you seek declaratory relief. And the court just rightfully found that they're actually seeking injunctive relief, and they didn't meet that standard. They had an adequate remedy, which is monetary damages.
Isn't it true that the DJ does not require completely injunctive relief? There's other relief within the causes of action that just seeks a DJ absent injunctive relief.
Yes, there is some other relief within the declaratory judgments that seek what you could frame as
Why should
declaratory
that
relief.
get dismissed?
But the court,
Irreparable harm is not an issue.
for those, the court has, and even in their papers, they state the standard. The court may issue a declaration in its discretion, and the court has discretion under the circumstances of the dispute whether to issue that declaration or not. And the court here found they are basically seeking injunctive relief by most of their declarations. It's clear that's what the relief they're seeking, and that the court doesn't feel that those declarations should be granted and dismiss them based,
On what
with the injunctive. On the
There's
basis.
no irreparable, if the irreparable harm is no longer an issue because it's not injunctive relief, what was the basis
The other
of the
base-
trial court, let me finish,
Sorry,
please,
sorry.
to dismiss out the remainder of the relief? Thank you.
Sorry about that. The other basis is that the other declarations are seeking claims for breaches of contract. They're saying declare that they breached the contract, but they don't assert a breach of contract claim.
Let's
There's-
take the signs. Let's say, for instance, there's one sign went up, prospectively, that you should not put up two other signs. Why can't that be part of the relief?
That's an injunctive relief. That's a enjoining them from putting up further signs.
So let's go with the valves, that they should have access.
That's how do we get they're saying they should have access by forcing us to rebuild something. It says access by doing one of these three things that cost hundreds of thousands of dollars.
Can't declare you in violation, that would be the end of it?
That is a cause of action for a breach of contract. They could bring that cause of action and seek damages or whatever relief they can under the contract. The contract
But
decides.
that wouldn't give them an adequate remedy at law. That's the whole point.
But we have case law cited in our brief that it is within the court's discretion from the First Department to deny declaratory relief when it is effectively a breach of contract claim and they are not asserting a breach of contract.
Thank you.
Thank you, Your Honor.
I'll be brief, Your Honors. As to the claim that we've had access through several events since this case was commenced, that's like saying we've been lucky enough to not have a fire. Yeah, we've had the several hours it takes to call a contractor, get them down, build a scaffold, reach the pipes, and turn off the water. I assure you, if the water was gushing in your apartment, the hours or days it would take us to do that would not be an adequate solution. We've been fortunate. We won't always be that fortunate.
So the relief that you requested is that they return they return everything to its
No, Your
original
Honor.
position?
Our fourth cause of
Condition.
action is bifurcated. In other words, we offer two solutions. On the one hand, there's the easy one. Just put back what was there. Everyone knows what
That's
was
the
there.
easy
It
one
worked.
to put-
Well, it was
That's
always
the
there.
the easy one?
The other one requires following Pollock or your own engineer. We didn't say that you have to follow Pollock. We just said, give us a means by which we can still access the fire hose, the roof deck, and the pipes. Right now, they're 20 feet up in the air. We didn't dictate a solution to them. But you know what? This court sees this all the time, albeit in an analogous situation of Yellowstone injunctions, where a commercial unit owner, albeit in a co-op, not a condo, creates a mess, and they have to solve the mess. And all we're asking them to do is solve the mess you created after we warned you. Now, as to the delay, it was only when Pollock came in and it disabused both parties of the notion that the scissor lift is code compliant, that we wound up where we are. And as Justice Shulman...
Well, I mean, actually, your friend stated that this was going on for a number of years, and there was no objection.
Well, there was an objection from the day one. There was just, we didn't go in and seek an injunction until Pollock told us that even if we got a scissor lift, we'd still be in violation of the plumbing code. And that code violation exists today. It will exist tomorrow. And what the court below said is my remedy is to effectively sue them for injunctive relief to get in, sue them to allow them for me to implement one of the solutions, and then sue them for the damages to be reimbursed. Respect, Your Honors, that is not an adequate remedy at law. That's just a never-ending string of litigation that guarantees we'll be back in front of this court.
Thank you. Schuler v. Kushner. Yes.
Good afternoon, Your Honors. Jason Levine for the plaintiff appellant. We submit that contrary to the motion court's conclusion, the affirmation of Dr. Seidman was insufficient to satisfy the defendant's initial burden on their motion for summary judgment. Well, the doctor's affirmation is voluminous. It's about 22 pages. We would submit it actually doesn't say very much.
Well, I don't agree with that. I think in the 22 pages, he carefully goes through the medical record, goes through the notes, goes through the imaging study, whereas your anonymous doctor was totally conclusory in his 10 pages and doesn't say anything. For example, he makes the conclusion at the time that Mr. Schiller presented to Dr. Kushner, his right knee was worse than his left knee. But the record here shows that, and the study showed that osteoarthritis of his left knee was far worse. That's why Dr. Katzman, historically, even in his own notes, say that the left knee was worse than the right. I can go on and on. Is there anything in your doctor's affirmation that said that he reviewed any of the imaging studies, that he reviewed the notes, that all it is conclusions?
I'll address that last question first, then go back to Dr. Simon. Yes, he does set forth in his his or her affirmation that he did review all the medical records. Doesn't specify in particular, I acknowledge that, but he does state that he does,
that he may have reviewed it, but he doesn't specifically. His whole point is that because your client did not say, I have pain, severe pain in my left knee, but it was rather in my right knee, therefore, that meant that he should not have done surgery on the left knee. That seems to be the gist of what your doctor said.
That's largely the case because, based upon...
Notwithstanding that Dr. Katzman's notes, right before he was referred to Dr. Kushner's, makes it very clear, patient presented with left knee pain repeatedly in February and March of that year.
Well, his note does say the plaintiff, though, testified to the contrary, where he did state that his right knee, he came in with right knee complaints when he first saw Katzman again in 2019.
By the way, your doctor doesn't challenge the manner of the knee replacement.
That's correct. No, it's a question that.
No problem with that. Your doctor doesn't challenge that shortly after surgery, he actually improved his range of motion in his knee.
That's correct. Yeah, the actual. Right.
And your doctor doesn't challenge that there's a real possibility that his going south on this circumstance was due to a genetic predisposition to scar tissue, which no one could have possibly contemplated when he had the surgery earlier.
He doesn't specifically negate that, but if I could just go back to Justice Shulman, to go back to Dr. Seidman's affirmation, because I think it's critical, because again, I disagree with the interpretation and analysis of this affirmation. Most of this, and many of these paragraphs of this affirmation, he essentially just sets forth the treatment and says, I agree with what Dr. Kushner did. He doesn't get into a factual or medical explanation to support his opinions. And I'll point out at page 861, paragraph 23.
Well,
it's on the heels of.
I'm sorry, look at paragraph 25. Didn't he say, I reviewed the radiology films and agree with Dr. Kushner that the left knee reveals severe osteoarthritis with significant loss of medial joint space. And the right knee has moderate osteoarthritis on the radiographs. Isn't that specific?
I would disagree. All he's doing is agreeing with what Dr. Kushner did. He's not explaining his opinion.
He said, I reviewed those films. That means he's using his own personal knowledge of the films and not just reading a report and saying, I agree.
I would submit he would therefore need to explain it, though. He needs to factually explain it. And again, I would just point to paragraph 23. It's on the heels of Kushner's exam in which he found limitation of motion in both knees. He says, at this point, it is my opinion that decrease in range of motion was not going to improve with additional physical therapy, and a total knee replacement was indicated. First, there's no medical evidence to support that.
You have time on rebuttal?
Oh, thank you, Your Honor.
May it please the court, my name is Ruby Ray, DOF PC, representing Fred Kushner, MD, and the Hospital for Special Surgery. I'm going to go specifically to page 23, which the plaintiff appellant made a note. Dr. Seidman's affidavit begins with, at this point, meaning this is not the sole reason, this is not the sole paragraph within which he bases his opinion. Set forth before that and after that, he goes through in extreme detail the indications for this surgery. Primarily, one should note that Dr. Katzman ordered an MRI in 2019 only of the left knee, not the right knee, because the plaintiff complained of left knee pain. So even if the patient began to complain of right knee, it was specifically explained to the patient, and Dr. Seidman confirmed that whenever you have pain in your left knee, you tend to shift to your right knee, developing compensatory symptoms. And that's why his condition was beginning to get progressively worse. Additional physical therapy would not have helped because there was bone-on-bone contact at that point. That is not helped by physical therapy. That is helped with surgery, and Dr. Seidman explained that, as well as Dr. Kushner's.
And he had previously undergone physical therapy.
I'm sorry?
He had previously undergone physical therapy.
Correct. In 2019, he was diligent in performing physical therapy, but by summer of 2020, the left knee pain had shifted to the right knee, where he was in extreme pain he described that was off the charts. That is the indication for the surgery, because that we now see compensatory symptoms developing.
Thank you.
Thank you.
Just very briefly, Your Honor, with respect to counsel's comment about the testimony regarding the off-the-charts knee pain, plaintiff testified specifically he was not referring to his left knee, he was referring to his right knee. That's at page 151 and 152 of the record. And again, I would submit that, even Dr. Katzman, that's medical evidence in this record, which he himself at page 798 recommended continued physical therapy on the knees, both left and right. There's no indication there for surgery. So unless the court has any further questions, I'll rest on the arguments in our brief.
Thank you.
Thank you.
Fuentes v. Parkchester South Condominium. Yes, you may proceed.
Good afternoon, Your Honor. Sarah David for the appellant. Before you is a straightforward case.
So your defense to this case is that you're not responsible for the sidewalk because you're a tenant. This is the obligation of, it's a city sidewalk and it's the obligation of the condominium. But in the bill of particulars, the plaintiff raises the issue that, well, you made, without any detail, but just says you made special use of the sidewalk. Have you adequately dealt with the issue of special use?
Respectfully, yes, Your Honor. In order for a commercial tenant, which is what my client's role is, to be responsible for a condition on the sidewalk under the special use doctrine, there must be two elements proven. One is that the tenant is in exclusive possession and control over the area of the sidewalk, and two, that the special use must be shown to have proximately caused plaintiff's injury. Typically, in special use cases, we see the installation of something on the sidewalk, whether it's a sidewalk cafe, a driveway, a ramp, something
So
else.
Weisskopf, it was the installation of a, the
Subway entrance.
The subway entrance, right? And so it's clear that your client did not install this cellar, the cellar door, right?
So the cellar door is actually not next to where this accident happened. So the cellar door is in the vicinity, but plaintiff identified an expansion joint between two of the sidewalk flags, remote from where the cellar door itself is, as the area where she tripped
So the
and fell.
expansion joint is what she claims to have fallen on, right?
Correct, not the
But
cellar
there's a
door.
crack going from the extension joint to the cellar.
Right, 2.5 inches, right? The crack is 2.5 inches from the cellar.
No, I believe that it's 2.5 inches is the size of the crack. She was saying that they're not the crack from the expansion joint
On the
to the
picture, it
cellar
looked
door.
like it's more than a flag away, didn't
Right.
it? The expansion joint.
The expansion joint is more than a flag away from where the cellar door is, correct? And my client's use of that.
By the way, in Weisskopf, the subway case, there was expert evidence submitted that tied the defect to the subway entrance, right?
Correct, and there's none of that here, Your Honor.
That's the only case that the plaintiff relies upon.
Correct.
So
That's
is there
correct.
anything here tying the defect to the cellar door?
No, Your Honor, there is not.
So who bears the burden to show special use on your motion for summary judgment?
On my motion, it's my burden to prove that there's no special use, and respectfully, I believe that we showed that. My client's testimony is that their sole use of this area of the sidewalk was to occasionally bring in deliveries through the cellar door. As this court has held in Tyree versus Seneca Home Attendant Program, the occasional use of a sidewalk to receive deliveries is not a
Guys,
special use.
whisper a little lower. Hello? Could you whisper a little lower, please? Thank you. Appreciate it. I'm sorry, Counsel, go ahead.
No problem. In Tyree, this court held that the occasional use of a sidewalk to receive deliveries does not constitute a special use.
But did you explain in your moving papers what you meant by occasional use?
Respectfully,
How often would you receive deliveries? What type of deliveries would you receive? What kind of use you made of that particular spot on the sidewalk?
my client's testimony, my client is a pharmacy. So the main entrance to the pharmacy is around the corner from where this cellar door is located. My client testified that typically they brought deliveries in through the main entrance.
They said, but your client did testify that they sometimes did deliveries through the cellar.
Sometimes, correct.
But that was it. There was sometimes he or she could not remember how many times, how those deliveries were made. I mean, there are cases dealing with hand carts, maybe motorized vehicles transporting goods over the sidewalk. Didn't say what was used in order to complete those deliveries.
Well, those deliveries would have been made by outside vendors. So how they use them, whether it was hand carts or otherwise.
Well, was that in the record, that the deliveries would have been used by outside vendors and that your client would not have had anything to do with assisting in those deliveries?
My client is the recipient of the deliveries. So to the extent that deliveries were being made by vendors, there are pharmacies. So however the vendor.
This evidence is elicited at Desai's EBT, where Desai is questioned, or Desai is questioned by plaintiff's counsel. And plaintiff's counsel doesn't choose to ask any of these questions.
That's correct, Your Honor.
Isn't it even more simple to say that Mr. Desai had no knowledge whatsoever as to the process of deliveries. I'll read it to you. 262. Question, when deliveries come into the pharmacy, do you generally oversee them? And then there's an objection. And then the question, back in May of 2017, A, I don't remember. He doesn't even set forth his knowledge of what deliveries were. So he doesn't give us any information as to any type of deliveries. So he basically doesn't know anything about the process.
Respectfully, how deliveries were made through this cellar door has nothing to do with this condition on the sidewalk remote from where the cellar door is. There's no evidence that this crack between the expansion joints had anything to do with the fact that there also happened to be a cellar door nearby. Anyone using this sidewalk, which was not the responsibility of my client to maintain, it was Parkchester's exclusive responsibility to maintain, and that's their testimony. They acknowledge it. Anyone using this sidewalk could have caused this condition.
Were the cellar doors exclusively for the use of your premises?
They did lead exclusively to the basement of our premises. However, there is no evidence that anything to do with the cellar doors relates to the expansion joint where plaintiff claims to have fallen. She hadn't walked over the cellar doors. She hadn't approached the cellar doors. She was coming from the corner, approaching that area.
But the expansion joint is next to the cellar door, right?
There's actually a slight decline from the cellar doors. The sidewalk actually slopes in that area.
So it relates to the cellar door, right?
Respectfully, I disagree, Your Honor. It is removed from where the cellar doors are located. There's no measurement.
So is that an issue of fact, or is that clear, that the expansion joint has nothing to do with the cellar door?
Respectfully, I think that it's clear, and Your Honor is showing the picture that shows that it's,
You see
can't
the
see
crack
the angle.
actually going from the cellar door to the expansion point.
However, you can't tell in that picture, but it's actually a decline from the
That
cellar
would be an
doors.
issue of fact, right?
Respectfully, there was nothing in the opposition to call into question the special use. And even if my client used that cellar door to receive some deliveries, this court has held in Chowdhury, in Tyree, in Hernandez, that this limited use to bring in deliveries through a cellar door does not constitute a special use for which a commercial tenant can be responsible. My client is undisputably not statutorily responsible and not contractually responsible for maintaining or repairing the sidewalk.
You do have time on rebuttal.
Thank you.
Good afternoon, Your Honor. Stephen Lane for the respondent. Just briefly.
In Keach, we said, Keach versus 30 East 85th Street Company, we said, moreover, its receipt of deliveries on trolleys transported over the sidewalk to its store did not constitute a special use of the sidewalk. Similarly, Tyree, the only case you cite is Wyckoff. You don't even deal with the cases cited by the defendant, which refute that you have a special use of a sidewalk by getting these deliveries.
Respectfully, they don't, Your Honor. And those cases are distinguishable. For instance, in Tyree, we weren't talking about a special use of a vault door.
Well, which case supports your position? I mean, you cite to Weisskopf, where there's an expert's affirmation that the subway rail, the subway entrance that had been put up, caused the defect in the sidewalk. And clearly, there's a difference between a subway entrance on the sidewalk to cellar doors, which you see all over the city. You have these cellar doors in front of buildings. There's clearly a difference between a subway entrance and these cellar doors.
Well, respectfully, with regards to special use, I'd say there's no difference, and you can substitute one for the other. This case, Weisskopf's on all fours with the present case. The fact that there was no engineer, I'll bring to the court's attention, the burden of proof here is on the defendant. This is a motion for summary judgment. However, there is a crack emanating from the vault door, similarly as it was to the rail in the subway station. Counsel concedes that Weisskopf shows a special use for the subway, and the fall did not happen on the subway rail. It happened on the adjacent sidewalk flag, as did here. That being the case, that's on all fours.
So it's your position that any place that you have these cellar doors in front of a building, whoever is utilizing that basement space, whoever is utilizing that cellar, that turns the use of the sidewalk. It's not, the special use is not the cellar doors, it's the use of the sidewalk becomes a special use. That those cellar doors turn that tenants, that businesses' use of the cellar doors turns makes them responsible for the condition of the sidewalk because it's a special use?
Yes, for that flag that surrounds the special use, certainly. It's analogous to a driveway, which is a special use. Typically, you have a ramp, and then you have to drive over a sidewalk.
Every tenant, every business becomes responsible for the condition of the sidewalk when they have access to those cellar doors.
They have to keep that section of the sidewalk in a reasonably safe condition for foreseeable users. I think that's the law.
And the fact that the duty to keep the sidewalk in a reasonably safe condition is imposed on the city or on the building owner gives way to the fact that now they're also responsible.
It doesn't alleviate...
Even if they've undertaken no duty, because there's no question here that the pharmacy did not do any maintenance on the sidewalk. That testimony is uncontroverted. So even in the face of that, they're responsible.
Correct. Only as the area of the special use. It doesn't matter who caused it, created it. As a special use owner or tenant in this case, they have a responsibility to keep that portion reasonably safe. As it doesn't relieve the building owner under 7210 with the same obligation.
Cellar doors equal special use.
Yes, for sure. If she tripped over the cellar door, I don't even think we'd be arguing that it's a special use.
So, counsel, you're not arguing that the cellar door itself, without the problem with the crack and the surrounding area only with regard to the cellar door, you're not arguing the entire sidewalk then becomes the special use?
Of course not. Absolutely
I want to make sure.
Yeah, so it's because the crack emanated from the cellar door.
Exactly.
And not the cellar door in and of itself as constitutes a special use.
Correct. The cellar door is a special use.
Thank you.
Thank you.
Respectfully, you've touched on it.
You don't make special use of the cellar doors. It's the special use is of the sidewalk.
Well, the only part of it that my client could arguably be found to have exclusive possession and control over, which is the requirement under the special use doctrine, is the cellar door which led to the basement.
No, it's the crack. It's the crack emanating from the cellar door.
But my client had no contractual responsibility or statutory responsibility under 7210.
Well, the case is the fuel cap which leads through the sidewalk, which is the Thomas case. That's the fuel cap is the special use, and if someone trips or something, that would be would impose liability.
Under the RPL statute, yes. Whereas, and that's a separate statute that obligates the owners of caps and grates and installations in the sidewalk to maintain the area within 12 inches around
So if she had tripped on the cellar door, is there a special use?
That would be a different case. And as counsel said, we probably wouldn't be here because that would have been a case where she tripped over the area that my client had access to, whether exclusive or otherwise.
So why is that different from the crack emanating from that cellar door? Why does it not include the crack emanating from the cellar door?
Because my client did not have exclusive possession and control over the sidewalk. That possession and control, A, it was a public sidewalk, but B, the owner of the property, Parkchester, expressly testified that they were exclusively responsible for control and maintenance and repair and inspection of the sidewalk. We're talking about the difference between a sidewalk flag and the metal vault door that led to the basement. And that is, I think, a crucial distinction because—
So, counsel, you didn't present any expert testimony, like an engineer, to rule out that the crack emanated from the vault door, which makes special use of the sidewalk.
That's correct, Your Honor. I did not.
So how did you meet your burden of proof that would exclude the possibility that the crack emanated from the door, the cellar door?
The only use of the cellar door was to occasionally bring in deliveries. There's no evidence that the occasional use of the cellar door to bring in deliveries,
How do I know that? There's no expert testimony. As a matter of fact, there's no testimony by anyone that talks about any usage of the cellar door. So you're basically showing a gap in the plaintiff's papers rather than producing any independent evidence to show how this crack occurred.
Respectfully, I would argue that it's the same evidence that was produced in Tyree and the same evidence that was produced in Chowdhury, which interestingly involves another Parkchester commercial tenant property, which was
And we have
decided
held
just last year.
several times that use of the sidewalk to make delivery into the building does not constitute a special use. Tyree, Jordan, Rodriguez, Thomas.
Chowdhury, exactly, Your Honor.
Thank you. Thank you both.
Thank you. Happy Thanksgiving.
Last case for argument is 885-887 Caldwell v. 885 Corp. Justice Mendez is recused on this matter. The rules of the court are if there is a tie, a fifth judge will be vouched in. Mr. Pantoja? Good morning. So preliminarily, we'd like to clear something up. You are represented by counsel, according to your papers. You can step to the microphone. What is the name of the firm who represents you?
The Forcina, excuse me.
I'm sorry?
I'm sorry, Your Honor.
What is the name of the firm which represents you?
The Forcina Law Group
And where are they?
in Middle Village, New York.
Why are they not here today?
I'm proceeding pro se.
You are represented by counsel. You cannot proceed pro se.
Just for purposes of argument.
I'm sorry?
For purposes of argument.
You are represented by counsel. You cannot proceed pro se. Where there is a representation by counsel, you are precluded from proceeding pro se.
Yes, Judge.
So then I guess the appeal would be deemed submitted.
Yes, Your Honor, if that's what Your Honor is
Well,
ruling on the issue.
no, I mean, that's the rule.
I did make a motion, Judge.
Well,
to
you
be-
made a
to be heard
motion,
today.
but again, you're represented by counsel. So as you are represented by counsel, you would not be able to make a motion on your own, one. Two, you were also disbarred in 1996, so you cannot represent yourself as an attorney, which is the other issue.
Yes, Your Honor. But
So the matter is submitted. Thank you all. Have a very happy Thanksgiving.
thank you, Your Honor.